So you're gonna talk. Got it.
repeatedly that the state is going to open the door by putting these witnesses up, and that the state will somehow inadvertently do something that would cause the defense to be able to walk through that door. And out of an abundance of caution, I filed this brief just to make sure that we were all on the same page, because I don't know what cross-examination questions are going to be asked of regular people, and I don't know what their responses are going to be to cross-examination questions. So I just wanted it on the record. And this is, of course, per Montgomery versus the state, 350 Georgia App 244, a 2019 case about the way to handle non-responsive answers from witnesses who may inadvertently say something that the other side considers to be good character evidence. And in that particular case, they said the party has to have the intention to put this person up as a character witness, and the other side does not get to go gotcha and put in evidence that's been excluded simply because of that. In addition, in Strong versus the state, 309 Georgia 295, a 2020 case, if inadmissible evidence were to come in, the opposing party must object.
Hold on, y'all, hold on.
You can't just consent to, well, inadmissible evidence.
Hold on. I'm gonna go to another link. Hold on.
The reason they're fact witnesses and this is a relevant issue is because the defense has put in evidence that Mr. Arbery walked into the neighborhood. They have not conceded in any way that he was a runner and or a jogger. This is now, because of the defense and their openings and the way they presented this evidence, an issue in dispute. So at this time, we feel it's relevant that he was in fact a runner slash jogger. We're not intending to elicit why he did these things or what they were for. It's just a fact that he was that person. And so we just direct you to our brief if this were to become an issue. We do not wish it to be, and we don't anticipate that happening. But once again, these are non-law enforcement regular folks who are going to be taking the stand now. Thank you, Judge.
Good morning, Your Honor. So I thought the court had ruled pre-trial that Mr. Arbery's intent in the neighborhood that day was not a matter before the jury and was not relevant. We didn't put in evidence that Mr. Arbery walked in the neighborhood. The state did. So I thought we weren't getting into Mr. Arbery's intent in the neighborhood that day, Mr. Arbery's intent in the house that day. The court forbid us from putting in evidence about those things. So what's the relevance of the state's witnesses to say that he's a jogger? The court's already ruled that's irrelevant. Now, any witness that testifies will be subject to cross-examination. I'm not going to trick a witness into answering questions that open the door. I understand how the law works, but I don't see the relevance here where the court has specifically said his intent in the neighborhood that day is irrelevant to this trial.
Mr. Oak.
Just to adopt the argument made by Travis McMichael's attorney on behalf of Greg McMichael, I do so now, and just add it into it a couple of corrections. We've not argued that Ahmaud Arbery walked into the Satilla Shores neighborhood. What we've argued is that the state introduced a video that shows him walking into the yard and up to the house at 220 Satilla Drive. He may have walked into the neighborhood and walked to the house. He may have run into the neighborhood, but the video we have is of him walking down the street, and then into the yard and into the house. And that's the first one. The second response to his being an avid runner or jogger, it's logically true that he could be both an avid runner and avid jogger. In fact, we don't have any reason to dispute that. But that on some occasions, when he engages in the activity we call running or jogging, he's doing it for other motives besides physical, mental health, or whatever other reasons a runner would run. And we've offered those before. I made an argument here, seems like a month ago, but it was probably 2 weeks ago. And it goes to this issue, and then I'm done. The state says, by offering this evidence, this is an answer to why was he running on 2/23/20. I mean, the evidence is meant to allow an inference to be made in argument that on this occasion, on that day, his motivation for running is the same one as on many other days when he ran for mental health or physical health. And we have some evidence that so far we've not been allowed to introduce to suggest, well, there may be a different answer to that why question than the one the state wants to argue from the inference they'll make that he's an avid jogger on other days, therefore he was jogging on this day. Under 401, it's simply not relevant. And if it's a balance test under 403, then it ought to open the door to the defense at least to offer an alternative explanation for it.
Mr. Shaw.
Your Honor, we join in the motion as made by Mr. Sheffield and in the further response by Mr. Hogue.
All right, let me do this because I have my. I don't remember a formal response coming in from the defendants. That was more of an advisory brief that was submitted. Correct?
You mean what the state wrote?
Correct.
I think the state was just trying to identify this
The
issue
issue
could
as
come
it
up.
came
We
up.
did not
Okay.
respond with our own.
Except we did file motions regarding the admissibility of Mr. Arbery's being on probation as the alternative explanation for his running. So in a way, we did respond.
Addressed just before trial. Yes.
And I do believe there was a filed response to this issue concerning 404B character and whether or not the introduction of what was going on in Ahmaud's mind and speculation about why he was in Satilla Shores can't come in because, for the same reasons that the court would not allow the 404B evidence of the defense in, because the argument of the state has always been and the court's conclusion has always been what Ahmaud Arbery was thinking that day is not relevant in this case.
Let me, I can take a short recess. Let me look at what I have. I've got a notebook in the back with all the submissions. I just want to make sure I'm clear on what I have and based on the arguments made here, come back with a ruling. All right, we're in recess, hopefully very brief. Please see. All right, we're back on. Defendants are all present. All right, I took another look at 4.72, which is the brief that the state had filed on character witnesses and opening the door in consideration of what I have heard this morning. So I do have a question before I get too much further. The brief that was submitted indicates that these lay witnesses that the state intends to present, and I will read from 4.72. State's anticipating the lay witnesses who knew Mr. Arbery personally or who saw him running or jogging in his neighborhood or in the surrounding neighborhoods in Brunswick, Georgia. What is the proffer on these lay witnesses? Are we talking about just generally running, or are we talking about in Satilla Shores? I need something more specific.
Yes, Judge, at this time, Ms. Olivier will give you a proffer for the 4 witnesses we intend to tender.
Your Honor, the first one, Ms. Flowers, she should testify that she has seen him running in the Fancy Bluff, Boykin Ridge area, which is where he lived. She also saw him running on Highway 17, which is the highway that separates Satilla Shores and Royal Oaks from that Fancy Bluff area. So in that area surrounding Satilla Shores.
Anything more than that? Time of day? Whereabouts on 17?
He would run all day, during the day. Also, she's seen him during the nighttime hours. She's also seen him on Highway 303, which is also called, I believe, Blight Island Road. So night, daytime, she's seen him all times, Judge. And she will also get into the clothing that he would wear when he runs. And I think that's about it for her. We intend to tender the in-life photo through her as well. And I don't know if the court has a question for me before I move on to the other ones.
No, go ahead.
Okay. So Linda Randall, she lives on Andy Tottenson Road. She's going to testify that she also saw him running in that neighborhood, and he would run for long periods of time. And the way he would be coming in terms of the direction, in addition to the timing, she would say that he would probably be running out past Highway 17 in that Satilla Shores, Royal Oaks area as well.
Sorry, and he would probably be running in the area past Highway 17.
The Highway 17 and across the highway to the Satilla Shores, Royal Oaks area.
That she had direct knowledge of it, or she
saw him.
She saw him run across the road
on Highway 17.
Yes, so she saw him the way her house is positioned. She would see him going and then coming back that direction where the entrance to Highway 17 is. Danielle Stoddard will testify that, similarly, Judge, that she saw him in her neighborhood, Fancy Bluff neighborhood, and she would also see him around that Highway 17 area when she would be bringing her kids back from school. And Ashley Wittenberg, She will testify that she saw Ahmaud running in the Boykin Ridge neighborhood, she would see him running at night when it's dark, which of course is an issue in this case because we have the defense attorneys saying, you know, he's in Mr. English's construction site at nighttime. What could he be possibly, you know, doing there? So she'll testify to the nighttime running as well. And those are all the witnesses we have to testify on that subject. Okay.
Well, I'll tell you, at this point in the evidence, what I have got in my notes is that the issues that have been raised, I think the first one was through, I think it's Miss Parr, maybe her parents were the Parrs, but Miss Parr. She was asked specifically by the defense about whether or not she had seen Mr. Arbery running in the neighborhood. Mr. Albenze was also asked about whether or not he had seen Mr. Arbery running in the neighborhood. I have not heard the questions asked, but based on the proffer, the court's concern is that none of these witnesses are actually testifying or rebutting any evidence that has been brought out by the defense. And the evidence itself would require one to make that logical leap that the court's concerned about with other evidence on why Mr. Arbery was in the neighborhood at the time. They don't actually place him in the neighborhood at any time. So again, the court's, if I'm being asked for a ruling without hearing the evidence, the court is indicating that if this is the type of evidence that comes out, at least in the state's case in chief, depending on how it's worded, it may end up opening the door to the why question that I have addressed in other orders of this court. Now, whether this comes out as rebuttal at some point, it really depends on the evidence presented, because again, what I have heard is that there is evidence from witnesses that was elicited by the defense that witnesses did not see him running actually in Satilla Shores. There are other questions here that sounds like are out there, like what clothes he wore when he ran. That is not something that has been brought out at this point, as I recall, as far as evidence or argument. The time of day, the times of day, I guess, that are involved in the various incidents that are before the court. So this could be rebuttal, but as far as the state's case in chief, strikes me as this gets us to the why question.
Understood, Your Honor. At this time, we will then just call Carol Flowers solely for the in-life photo, and having discussed that at the break with defense that may be your ruling, we understand where the defense is going to go with Ms. Flowers and where we're going to go with Ms. Flowers. So if we may have 5 minutes just to make sure we're on the same page as a team, we'll go ahead and do that.
Let's take a 5-minute recess.
Thank you, Judge.
Be seated.
All right, we're back on defense president represented by counsel, Mr. Goff.
Yes, Your Honor, I have a motion to make. This time we would ask that the Honorable Reverend Jesse Jackson, who I believe is still here. Of course, he is, Your Honor, I think we all know, an icon in the civil rights movement. He, not just a witness to it, he the personification of it. And in other circumstances, I think everybody would be happy to have their picture taken, maybe get an autograph. But in the context of this trial, we object to his presence in the public gallery inside the courtroom. We note that there is a jury assembly room capable of holding, depending on how we socially distance, several hundred people, where these proceedings are being televised live in real time. The issue as brought up previously is how many pastors does the Arbery family have? We had the Reverend Al Sharpton here earlier, last week, and I'm not keeping track, and I think the court has indicated the court doesn't intend to ask anyone to keep track of who was in the gallery. But I don't know who Mr. Jackson, Reverend Jackson, is pastoring here. My understanding is, and I was given names, that the Arbery family have local pastors. They also have attorneys. Mr. Arbery, Marcus, has a team of lawyers to comfort him through these proceedings. Certainly, Ms. Cooper has been amply comforted by her legal counsel. And we are concerned about whether it's conscious or unconscious, the impact of their presence with respect to the jury and with respect to the proceedings in this case. And I guess the next question is, which pastor is next? Is Raphael Warnock going to be the next person appearing this afternoon? We don't know. Your Honor, I would submit, with all respect to the Reverend Jesse Jackson, that this is no different than bringing in police officers or uniformed prison guards in a small town where a young black man has been accused of assaulting a law enforcement officer or corrections officer. And as I have noted before, the city of Brunswick is indeed a fishbowl. Your Honor, I understand that the court, maybe I misunderstood the court the other day, but I think the court had indicated it was the court's understanding or assumption that the Arbery family is giving up seats in the public gallery so that these gentlemen may be present. With all due respect, Your Honor, the seats in the public gallery of a courtroom are not like courtside seats at a Lakers game. There are no First Amendment rights in the public gallery of a courtroom. There is no standing of any particular individual to be present in the public gallery of a courtroom. And there is no reason for these prominent icons in the civil rights movement to be here. This is a case that has been postured in the media, I believe, by Marcus Arbery's attorney Benjamin Crump, if not Lee Merritt, and certainly reported by the media as a quote-unquote test case for where the civil rights movement is in 2021. So with all due respect, I would suggest, whether it's intended or not, that inevitably a juror is going to be influenced by their presence in this courtroom. And while there seems to be some argument over how much the jurors can see, and I can certainly supplement the record, but I took pictures last week, and it is very clear that most of the jurors have a complete, unobstructed view of the entire gallery. And again, we are concerned about our client's right to have a fair trial and the impact of the presence of these individuals is going to have on this case. And we're asking the court, and again, with all respect to the Honorable Reverend Jesse Jackson, that he be observing these proceedings from the jury assembly room where they are being streamed live, rather than sitting here in the courtroom where he can visually interact with the jurors in this case.
Anything from the remaining defendants?
Your Honor.
No. Anything from the state?
No, Your Honor.
All right. Mr. Goff, at this point, I'm not exactly sure what you're doing. I have already ruled on this court's position with regard to the gallery. And with all candor, I was not even aware that Reverend Jackson was in the courtroom until you started your motion. I have indicated the court's position. The court's position hasn't changed. At this point, it's almost as if you're just trying to continue this for purposes other than just bringing it to the court's attention. And I find that objectionable from the court standpoint. I have said over and over and over in this trial that I am attempting to ensure that in this courtroom that the defendants receive a fair trial. And I will continue to do that. I have heard the objection. I have ruled previously on my position with regard to the gallery, and that is unchanged.
And I'm not questioning the court's ruling, but the court...
I'm done talking about it, Mr. Goff. I've heard the motion. I understand what your position is, and if it's simply just to point out that an individual is in the gallery, it has been done.
Do I understand that I'm not to do that again?
I'm telling you that the court's position has remained the court's position, and unless anyone in the gallery is disruptive or here to cause some demonstration that will distract from the presentation of evidence in this case, the court is not going to single out any particular individual or group of individual as not being allowed to be in this courtroom as a member of the public. That is consistent with my prior ruling and will remain the ruling of the court. If there's a disruption, you're more than welcome to call that to my attention. If there's a problem, call that to my attention. But on this particular issue that you brought up previously, which has now been effectively renewed, I think I've been very clear we do not need to discuss it any further.
And I've been very clear of my desire to make a record. And thank you, Your Honor.
Is the state ready to proceed?
Yes, Your Honor.
All right, let's go ahead and get the panel.
All right, for the jury. Please be seated.
All right, welcome back. We are ready to proceed with the evidence in this case. State ready with its next witness.
State's ready. State calls Carol Flowers, Judge.
Swear to tell the truth, whole truth, and nothing but the truth.
I do.
Go ahead and have a seat.
I can, and I will try to shout. Good morning, Ms. Flowers.
Good morning.
Can you go ahead and introduce yourself to the jury? Just tell them your name and then spell it for the court reporter, please.
Carol Flowers, Carol Flowers.
Okay. And how are you today?
I'm good.
Good, good. So, do you live in Brunswick?
I do.
Okay. What part of town do you live in?
Boykin Ridge.
Okay, that Boykin Ridge area?
Yes.
Okay. Is that close to like the Fancy Bluff area?
Yes.
Okay. And are you married, single?
I'm married.
Okay. Do you have any children?
I do. I have 2 biological children and 1 stepdaughter.
Okay. How old are your kids?
28, 24, and 19.
Grown kids?
Grown kids.
Okay. And what do you do for a living, Ms. Flowers?
I'm a nurse.
Okay. I want to turn your attention to a person by the name of Ahmaud Arbery. Did you know that person?
Yes.
Okay. Can you tell us how you knew him?
He was my neighbor.
Okay. Are we talking like next door neighbor?
Yes. Right
Okay.
next door.
Right next door. Okay. Do you remember when you first met him?
In late 2011 or early 2012.
Okay. May I approach, Your Honor?
Yes.
All right, Ms. Flowers, I am approaching you with what has been marked for identification purposes as State's Exhibit 1. If you can look at that and just tell me if you recognize it.
Yes.
Okay, who's that depicted in the picture?
Quiz.
Okay. And you say Quez. Is that what you knew him as?
Yes.
Okay. Ay, ay, ay. And is it a fair and accurate depiction of Mr. Arbery?
Yes.
Okay. At this time, we would tender state swan. Thank you.
Objection.
Okay.
Greg McMichael?
No objection.
Submitted.
Permission to publish, Judge?
Go ahead.
Okay. So, Ms. Flowers, that's who you knew as your next door neighbor?
Yes.
Okay. Now, do you remember the day that he died?
Yes.
Okay. All right. That is all I have for you, Ms. Flowers. The defense attorneys might have some questions for you, okay?
Okay.
I do have brief questions, but I think we need a recess, Your Honor.
Ladies and gentlemen, if we could just take a moment, if we take a 5-minute recess.
It's all right for the jury.
All right, I took a recess because that's okay. All right, I'm just taking a recess. There was a little bit of commotion in the back. I wanted it to calm down a little bit before we started with any cross-examination.
Your Honor, for the record, I would note that the Reverend Jesse Jackson's mask is down below his nose, which I'm not a big believer in masks, but we, again, make that part of the record. And I'm sure the court can see what I'm talking about.
All right, it appears we have order back in the court. Let's get the panel.
Your Honor, may we approach?
The jury's not. I'll ask the witness to step down. Ma'am, can you go ahead and take a step into the hallway for just a moment? Okay, the witness is not present. Ms. Hook.
Your Honor, is there a way we can do this at the bench or?
We're making a public record of this. I adjourned because when the state was done, I heard some weeping in the back and was looking at the defense to move forward, and there seemed to be an indication that we should take a pause, so I decided to take a pause. That is all. I have order back in the courtroom now, so I tend to move forward.
And, Your Honor, for purposes of the record, I will have to note that I observed a number of jurors looking back. And that's why this is so difficult, Your Honor. We are advocates for our clients, but we are also human beings and parents. And there is no disrespect intended in these remarks, but my one and only purpose is to assure a fair murder trial for Mr. McMichael. And when jurors hear the weeping with a piece of evidence that is absolutely irrelevant and has nothing to do with the decisions this jury must make, but the law of Georgia allows it to come in, and then left with having jurors hear and see and visualize the emotion, and now to be comforted by someone for whom respect abounds. We're in a very difficult position now with this jury to have seen and heard and felt that when they go back to deliberate this case and to think about the decisions that do matter in this case. And as beautiful of an in-life photo as that is, it bears no relevance to any issue in this case. So while I appreciate the court taking a break and noting your having heard the crying up at the bench, I have to place on the record that not only did I hear it as well, I saw jurors looking back at what was going on in the gallery and then looking at me. So I'm asking the court to place that on the record. Mr. Goff and I may not agree on a number of things, but the idea that this may not be the best way to handle this sort of case has become now the issue that you asked him to bring to your attention, and that is, has there been any disturbance caused by that?
If I could just add, Your Honor was very aware of the issue of emotion in the courtroom and how it plays out in front of the jury. And I think went on the public record and warned the gallery not to engage in that kind of behavior, and I think instructed all of us to make our witnesses aware of any evidence that might come in that would cause that kind of emotional outburst, and did so with the goal in mind of keeping this trial about the evidence. It's becoming less and less about evidence and more about emotion with these kinds of outbursts and those kinds of photographs, which, again, to echo Ms. Hogue, have nothing to do with the issues in this case. A photograph that's 8 years old and bears no real resemblance to the person we saw in February of 2020. So I would join Ms. Hogue's difficult position. I think we're all in that same position on this side of the courtroom.
And make one state.
No, Your Honor.
All right. So let me tell you what we're doing. I heard at the bench, some weeping, not outward crying, not yelling, nothing along those lines. So the jury was asked to leave, and this was intended to, and I think is a good reminder to the gallery that there shouldn't be any outbursts, no matter what the evidence is, whether it's this photograph or anything else. But I will point out, with what's now beginning to happen here, I do not understand, Mr. Goff, why this motion keeps being made. It is a concern to the court because on the flip side, I've seen a news report where other counsel are indicating that everybody is welcome, come one, come all. We've got a little bit of, there's an odd thing going on here that I'm watching to make sure that I've got a clear understanding of as we move forward in this trial. And I've already put my rulings on the record with regard to public access in this courtroom. That has now somehow got conflated with a photograph that was not objected to as it came into evidence. I understand the defense...
It was objected to previously, Your Honor.
That particular photograph. Yes. Okay, and that's fair enough. And I misspoke there. And I misspoke. But the point being that there's other evidence that comes in, elicits responses. I've got issues that are starting to get conflated, and we'll watch what's going on. The court's rulings, again, on public access haven't changed. The evidence is being admitted. It is an emotional trial. That is not unique when it comes to murder trials, which is why the court prefaces a lot of murder trials with, I don't want any outbursts from the gallery. So again, to the gallery, I don't want any outbursts from the gallery. This is not the place for it. We're trying to get a fair trial for the defendants and ensure that the evidence gets presented in such a way where counsel have the opportunity at some point, hopefully in the near future, to make an argument to the panel about what the evidence actually says happened on the day or days involved here. That's what we're doing. And I don't have anything else to say about it, Mr. Goff.
I might suggest that the court consider some Supreme Court precedent
on access to the courtroom?
Maxwell v. Shepherd, Stella v. Texas, and I don't remember the other name of the party, but Musladeen and Justice Souter's concurrence.
Well, why don't you tell me what your understanding of it is, and then I'll go ahead and take a look at it, or give me the full cite if you're going to ask this court to do something in the form of a motion. If you're not moving the court to do something, I'm not terribly interested in continuing this conversation.
Your Honor, I will file a written motion as soon as I can finish it. You might well imagine that we're talking about issues that we don't ordinarily encounter, even in a criminal case.
Well, don't throw up a trial balloon without some support at this point. If you think that those cases in this context move the court to do something, cite them, let me know what it is, and we'll move on from there. Because I've heard a lot of discussion here, and this is the first you're now citing case law on this. So, if you want to file something, go ahead and file it.
Thank you, Your Honor.
Thank you. Is the state ready with this? I'm sorry, it's not even ready. Let's get the witness back up. State to pass the witness, yeah. And let me back it up. If you're moving for a mistrial, you need to move for a mistrial.
I move for a mistrial.
Based on?
Based on the presence of people in the courtroom and the public gallery.
Your Honor, I have to stop for my moment. We have a witness now on the stand.
If you go ahead and sit down, thank you.
Thank you.
And I do actually very much appreciate the court helping me maintain a record on this. We formally moved for a mistrial under the 5th, 6th, and 14th Amendments of the U.S. Constitution, parallel provisions of the Constitution of the state of Georgia. We contend that the atmosphere of the trial, inside and outside the courtroom, at this point, has deprived Mr. Bryan of his right to a fair trial. I understand that co-counsel vehemently disagree on some aspects of that motion, and if they don't want to join, that's their business. But I represent Mr. Bryan, and my concern, Your Honor, notwithstanding what in my observation would be extraordinary efforts on the part of the court to avoid anything that would interfere with the right of these defendants to a fair trial. At the same time, in extraordinary cases like this, additional steps have to be taken. We have not secured the front of this courthouse. The Transformative Justice Coalition still flies their banner virtually every day outside in what should be protected grounds. Your Honor, we have had numerous instances several instances during jury selection of nonverbal communications between the victim's family and jurors, or from juror to the victim's family. We've had several emotional outbursts during the trial of this case, notwithstanding the substantial efforts of the court to ensure that they don't take place. And we have had civil rights icons sitting in here in what the civil rights community contends is a quote-unquote test case for civil rights in the United States. Eyeballing these jurors, including one today with his mask down, which the court doesn't want to make part of the record, under Supreme... I rephrased that. Didn't make part of the record.
Thank you.
Yeah, I rephrased.
You made it part of the record.
Well, until the court acknowledges it, it's not part of the record.
Keep going, Mr. Coffey.
Your Honor, the case law out there in mob cases and other cases demonstrates all the ways that presence in a gallery can influence jurors in a case. And I certainly don't mean to suggest that Al Sharpton or Jesse Jackson or any other pastor belong to a mob, but at the same time, we are talking about organized behavior by whoever outside the courthouse leading up to this case. But we have all these community leaders fearful that the city's going to burn down. This isn't a mob case. If you testify against a gangster, they might burn your house down. They might burn your business down. They're not going to burn your whole city down. And that is the concern that I believe jurors have expressed during the voir dire process in that a county commissioner, a mayor, school board member, a bunch of pastors in this community, both black and white, have been talking about. So in that context, we believe the totality of the circumstances which is what this court looks at under Shepard v. Maxwell, under the totality of circumstances. This trial has been sufficiently infected, notwithstanding the best efforts of the court, to the point where Mr. Bryan's ability to receive a fair trial has become an open question. We think that line's been crossed. The court may see it differently, but we've made that for purposes of the record.
On behalf of Travis McMichael, we're constrained to join. I did notice jurors, a few, noticed the outburst. I don't think it gets any more difficult at moments like this for the family members to have to sit through the evidence. This moment feels unique in that the one piece of evidence that the state put up was not, so inflammatory, but there were several jurors that did look over. Their faces changed, the emotion, the sympathy that they felt. And to see then Mr. Reverend Jackson, whose autographed picture hung in my mother's law office for 2 decades, who is the ultimate figure of fairness and justice and equality, to see that, I don't think it gets any higher in terms of the impression that makes. And for those reasons, I think that makes this very unique. And that's why we're constrained to join, Your Honor. Thank you.
Likewise, on behalf of Greg McMichael, we are constrained to join this motion, but for some slightly different reasons I'd like to highlight. It was apparent from the beginning of voir dire that it was going to be difficult, even long before voir dire, that it was going to be difficult to get a jury who had informed opinions, and we worked very hard to do that. And we would have loved to have had a jury that represents the demographic composition of Glenn County, which would have been 3 or 4 African Americans on the jury. We were not able to do that. I think some comments by the court in denying the state's reverse Batson motion, I take exception to them, and with all due respect, but it's continued the difficulty we've had from the beginning in trying to determine, is this the right venue for this case? We hoped it would be. We wanted it to be. But in light of what's going on now and what has been the history of this case up to now, we are constrained to join the motion for mistrial, but for these slightly different reasons.
Let me be clear. I don't know what this talk about change of venue is. There's nothing wrong with this venue. We're not concerned about the venue, but we are concerned about the details as to how this trial has progressed, notwithstanding the extraordinary efforts that this court has made. And I certainly don't want the court to think for a moment that Mr. Brown and I don't very much appreciate the incredible amount of work the court has put into this and the thoughtfulness. But if the court's not going to grant a mistrial, I would humbly urge the court to consider adopting other precautions to ensure that the court doesn't wind up where the court has to grant that motion.
Anything from the state?
Yes, Judge. A mistrial is a proper remedy for incurable fundamental unfairness in the proceedings. There's a case from 1999. Casey, C-A-S-E-Y versus the state, 237 Georgia App 461, where jurors briefly saw the defendant in handcuffs, and that did not require a mistrial because there was no showing of actual prejudice. Quickly looking today, right now on Lexis, what we have is also Bird versus the state, B-Y-R-D. This is a Supreme Court of Georgia case from 1992. It's 262 Georgia 426. Basically holding that because the trial court took prompt, thorough, and curative action The outburst of the victim's relative did not deny a defendant a fair and impartial trial, and his motion for mistrial was properly denied. This court obviously took prompt, thorough, and curative action by having the jury leave immediately. In addition, don't want to cite something before I actually read it, so I'm going to take a look at it. We have Simmons versus the state, 308 Georgia 327, a March 13th, 2020 case. Simmons contended that the trial court abused its discretion when it denied his motion for mistrial in response to, and they put these in quotes, emotional outbursts of the victim's family members and friends. However, the Georgia Supreme Court saw no abuse of discretion. They then cited two numerous cases there, stating that trial courts are vested with great discretion to grant or deny mistrials because they are in the best possible position to determine whether one is actually warranted or not. Measures to be taken as a result of demonstrations and outbursts which occur during the course of a trial are matters within the trial court's discretion. And of course, such discretion will not be disturbed upon appeal unless there's a showing that a mistrial is essential to the preservation of the right to a fair trial. This was minor weeping in the back, and the court took immediate curative action. Additional action can be taken to instruct the jury there to ignore any sort of emotional outbursts that take place. And at this time, Judge, we ask that you deny any sort of mistrial based on the outburst, well, it really wasn't an outburst. It was, in the state's position, it was kind of a gulp and a weep, like that. And that was basically all it was that the state heard. So I just want to make sure that characterization, it wasn't somebody shouting, it wasn't somebody, as they say, falling out hysterical, nothing along those lines at all. So we ask that you deny any motion for mistrial on that basis. And ask that the court take kind of into consideration and disregard the, how am I trying to say, the mixing up or confluence of multiple arguments about Reverend Jackson being here and that somehow having something to do with the outburst or something like this. These are all very, very separate issues, neither which independently or even together at the same time require manifest necessity for a mistrial. We ask that you deny that mistrial.
I believe that's the last word.
Yes.
Well, V. Shepard, the court's looking at the totality of circumstances here. And under the totality of circumstances, we believe that a mistrial is warranted. I think the state has certainly accurately summarized the relevant law with respect to the court's discretion and with respect to whether an appeals court would reverse a determination by this court. But still, ultimately, it is Your Honor who makes that call. And that's why you get paid the big bucks, because you're the one sitting here as the umpire in the case. The advocates, we all see things from our perspective. You're the neutral here, and you make the call. But I would just submit, under the totality of circumstances in this case, from the commencement of jury selection to today, that these defendants can no longer get a fair trial.
It appears, Your Honor, there's some language in these cases about what is now incumbent upon the court. Until the state has to hold the trembling hand of the accused, I would suggest that these types of moments don't impact the state. They favor the state. And it is now incumbent upon the court to decide to grant mistrial or to present curative instruction.
I've asked for curative instruction as an alternative at this point.
Yeah. Well, the idea that you have to then potentially inquire of jurors and ask them if they heard it and if they noticed it, we're not asking for that. However, we're at 2 strikes. We've had one outburst that's been addressed. Now we've had a second. The court has to decide what to do.
All right, anything final, Mr. Hunter?
No further comment.
All right, it's in this court's discretion with regard to any outburst in the courtroom, taken into consideration, as well as the defendant's motion for a mistrial. So I cite to a couple cases. Let's see, Forney, I think it's Forney versus State, 255 Georgia 316, which actually recognizes that emotions are neither unreasonable nor unexpected during a murder trial. And the demonstrations and outbursts which occur during the course of the trial are matters within the court's discretion to evaluate. The court heard exactly what I described on the record, decided to remove the jury briefly, and it was ready to get started. Based on that outburst, the court is not granting a mistrial. As to the totality of the circumstances argument, which I think is the second argument that was presented by Mr. Goff, that gets back to what I'm starting to watch very carefully as far as what's going on in this courtroom with the jury, as well as the arguments that are being made by counsel. I'll point out that a number of times during jury selection it was raised that jurors were being influenced by individuals outside the court, and I think it was either 4 or 5 jurors were asked specifically whether or not they were influenced in some way by what was going on outside the courtroom. And they were not. There was no, actually, if I remember correctly, they didn't even recognize or see what was going on outside the courtroom. And as counsel are aware, because I have briefed counsel, there are steps being taken by the court during the jury trial to ensure that jurors are not influenced by anything happening around the courthouse. So then we start getting into what we have now with individual members or individuals coming into the courtroom. I will say that is directly in response, Mr. Goff, to statements you made, which I find reprehensible. The Colonel Sanders statement you made last week, I would suggest may be something that has influenced what is going on here. In response to that, and to his credit, Mr. Sheffield made some comments, but did say, come one, come all. And so now the court is faced with balancing a lot of things going on outside this courtroom and doing it in a way that respects members of the public's right to be in the courtroom, as well as what I'm trying to put out there is a fair trial, right? So you need to understand, everybody, that your words in this courtroom have an impact on a lot of what's going on. And so my measured response at this point is to balance all of that out and try to move forward with the trial. I'm not granting a mistrial at this point based on these arguments that are being made, because I think I'm not granting a mistrial at this point based on the arguments that have been made. Are we ready with the witness from the state? I'll be Mr. Sheffield. All right, let's go ahead and get the panel.
Please be seated.
All right, welcome back, ladies and gentlemen. We are ready to get back to the evidence in the case. Mr. Sheffield.
Yes. Good morning, Ms. Flowers.
Good morning.
I'm Jason Sheffield. We have not met before, right?
No.
Okay. I know that you have had an opportunity to talk with a couple of people investigating this case, and they interviewed you, and I think that's how we learned that you were the neighbor to Mr. Arbery. Is that right?
Yes.
Okay. And I think you were shown a picture of Mr. Arbery from around the time of 2012, 2013.
Yes. Yes.
All right.
We're unable to hear.
If you would just speak up just a little
I'd
bit.
say, maybe just that microphone, it's very, it needs to be pointed right at you. Or if you try to speak into it.
I'm not sure when the picture was taken.
Oh, okay. All right. I want to show you a couple of the pictures. I've shown these already to opposing counsel. I've marked them as defendant's exhibit Travis McMichael 12 and 13 for identification purposes. May I approach Ms. Flowers? Thank you. Ms. Flowers, I'm going to hand these to you and just ask you if you recognize the person in these images. Will you take them from me? Do you recognize the person in Travis McMichael's exhibits 12 and 13?
Yes.
And who do you recognize that to be?
Quiz.
And are those fair and accurate depictions of him? Do those fairly and accurately show who he is?
Yes.
Okay. I move defendant's exhibit 12 and 13 into evidence.
No objection.
Okay.
No objection.
All right. Very good. Permission to publish?
Yes.
Okay. I'm just going to show you defendant's exhibit 12. And I'll show defendant's exhibit 13. I don't have anything further. Thank you.
Anything from the additional defendants?
There you are.
No. Sorry. Anyway, you're
From the page.
all right. Thank you, ma'am. You may step down.
Thank you, ma'am.
From the state?
State calls Antis the Rao.
Swear to tell the truth, the whole truth, and nothing but the truth.
Yes, I did.
Go ahead and see.
Good morning, ma'am. How are you doing today?
Good morning. Fine, thanks.
Will you go ahead and state and spell your name for the record, please?
My name is Ann Kistler Rao, ANNEKISLER-RAO.
And ma'am, what do you do for a living?
I'm employed with the Georgia Bureau of Investigation, Division of Forensic Sciences, also known as the State Crime Lab, and I'm employed in the Trace Evidence Section.
Okay. And what is the trace evidence section of the GBI?
With the Trace Evidence Section, we analyze small, often microscopic pieces of evidence, such as hairs, fibers, paint, glass, fractured materials, and general unknowns.
And your specific occupation, is there a term for your job?
I'm a microanalyst.
And tell the jurors a little bit about your training and your education in trace evidence and microanalysis.
I have a bachelor's degree in biology from the University of Pennsylvania. I have a master's degree in forensic science from John Jay College. While I was there, I completed an internship with the New York City Police Department Crime Lab. I have been employed with the GBI Crime Lab for over 15 years, and I've completed extensive training programs in all of the areas that I perform examinations in. And I'm also certified by the American Board of Criminalistics in hair and fiber analysis.
And does your certification require you to keep up to date on the current subject matter within your area of expertise, take any sort of continuing learning, education hours, or anything of that sort?
That's correct. We have to have certain things like continuing education to fulfill points over the certification period.
And how long have you been a microanalyst?
For over 15 years.
During the course of those 15 years, have you continued to keep up your certification and your hours and your continuing education?
Yes, I have.
This might be a tough question, but do you happen to know or have a rough estimate about the number of cases you've done analysis on in your time in the GBI?
Probably over 1,000 cases.
And during the course of your employment with the GBI, have you come to court to testify at maybe hearings or trials, that sort of thing?
Yes, I have.
And have you ever been tendered as an expert before in the court in the state of Georgia?
I have.
You know roughly how many times?
Over 50 times.
Judge, at this time the state tenders Ms. Kistler Rao as an expert in trace evidence or microanalysis.
No objection.
No objection.
No objection. She's admitted.
Thank you, Your Honor. Were you asked to perform some sort of analysis for the case involving Ahmaud Arbery?
I was.
Okay. How many different analyses did you have to do for this case?
There were 2 analyses that were requested.
Okay. Let's start with the first one. What was the first one you were asked to do?
The first one was a fiber analysis.
Okay. And can you give the jurors a condensed or a simplified version of what fiber analysis is?
Fiber analysis is typically going to be, we will compare question fibers, which are fibers that are collected off of an item of interest where we don't know what their source is, and we'll compare those to a known source, such as an article of clothing, and determine whether or not those question fibers are consistent with the known source.
Okay. When you're comparing fibers, do the types of fibers matter when it comes to comparison?
Yes, we can compare any type of fiber.
Okay. Can you explain to the jurors a little bit more about maybe the difference between natural and synthetic fibers and maybe the ease with which those types of fibers are able to be compared?
Yes, so when we perform a comparison, we go through a number of different steps in our comparison. The first step is using a stereo microscope, which is a low-powered microscope. We use that to examine the general features of the fibers. So this can be done with both synthetic and natural fibers. The next step is the comparison microscope, which is a higher-powered microscope. There are 2 microscopes that are connected together by an optical bridge where we can see the question fiber and the known fiber at the same time under the same field of view. With natural fibers, we can look at the morphology of the fiber, so you can look at the general shape of the fiber to identify it. If the fiber is colored, you can look at that with both natural and synthetic fibers. With synthetic fibers, there are going to be extra features that you can examine, such as during the manufacturing process, they might add particles called delustrant to the fiber. They can have different cross-sectional shapes to the fiber. There are many different fiber types that you can have, like nylon or polyester. So these are the first 2 steps of our procedure, and those would be the differences that we would look at between natural and synthetic fibers.
Now, is this a multi-step procedure besides those first 2?
It is.
What else do you have to do?
The next step would be fluorescence microscopy, which is another comparison microscope where we'll shine different wavelengths of light on the fibers and different fibers can fluoresce different colors and different intensities, like bright or dull. After that, the next step is called microspectrophotometry, or MSP for short, and this is done with dyed fibers, and it is basically an instrumental technique that you can use to analyze the color of the fibers. So fibers that appear the same color under the regular microscope might give different spectra using this technique. The next step we have is called Fourier Transform Infrared Microspectroscopy, or FTIR for short. And this is done with manufactured fibers, and it can help determine the chemical structure of the fiber, and it will help you confirm what kind of fiber you have. And we can also do a melting point analysis with fibers that melt to compare the melting features of the fiber.
You put out a lot of terms for us, okay? So during these various steps, are these steps required in every analysis, or can you tell based on maybe a visual cue which steps you might have to take in each analysis?
So depending on what type of fiber you have, you would not complete all of the steps. So for example, if your fiber is not dyed, we would not necessarily be doing the MSP step to analyze the color. If the fiber is a natural fiber, we would not be doing the FTIR to analyze the structure of the fiber, because we can tell that it's natural based on microscopy alone.
And in the fiber analysis that you did for this case, were you given a potential sample of fiber to look at?
I was.
Okay. And can you tell the jurors what came into your office and where they came from, and what you did to compare the fibers that came through and then your results?
Okay. So what was submitted to me was what's called a tape lift. So it's where you take a piece of tape to collect fibers on an item, and that'll collect any fiber on the surface of the item. It was submitted by a police department. And then I also received a white t-shirt, which was submitted by our medical examiner's office. And I compared the question fibers. I took a sample of the question fibers from the tape lift. I compared 20 of these fibers to the known fibers of the t-shirt. I found that they were consistent in microscopic properties and fluorescence. These were white cotton fibers, so I did not go on to the next step in the procedure because they were not dyed and they were a natural fiber. And I found that the question fibers were consistent with the known fibers composing the t-shirt, so I could not eliminate these fibers as coming from the t-shirt. I reached this conclusion because white cotton fibers are a common fiber type, and they are prevalent, and they do have limited features for comparison. However, they were consistent.
So when you say cannot be eliminated as having come from the t-shirt, does that mean that they definitively came from the t-shirt?
I cannot say that they definitively came from the t-shirt. There could be another source possessing fibers that would also be indistinguishable from these.
But they were similar in characteristics.
They were consistent in all their microscopic properties as well as their fluorescence.
Do you know where this tape lift came from in terms of evidentiary chain of custody, that sort of thing?
I can tell you where it originally came from, who submitted it to us. Is that
who submitted to it, and where it actually came from in terms of the crime scene, if you know, and whether it's listed in your reporting?
It was identified to us as having being taken off of a truck.
And do you know the police department that submitted it to you?
May I refer to my notes?
You can.
It was submitted by the Glenn County Police Department.
And in your job, you get submissions from all over the state, is that right?
We do.
about fibers. Are fibers transferable between different objects?
Yes, they are. Anytime any two objects come into contact with each other, there's the potential for fibers to transfer off of one item onto the other and vice versa.
Like if you have a sweatshirt on or a sweater on and you take it off, there might be some fibers on the t-shirt underneath. Is that what we're talking about?
That's correct.
Okay. Now, do these fibers, does it matter what the object is in order for a transfer to happen? Are some objects easier to get transfer onto?
So generally speaking, the items
Relevant and generally speaking. If she has an opinion about this particular case, we'd like to hear it.
I can narrow it down, but I mean, I think in general she's able to explain the process of transfer, and then we can narrow it to a specific part of this case.
Again, if she's going to render opinions in this case on this evidence, that's great. We want to hear it. If she's just going to generally talk about things that are not relevant to this case, then we would object.
I understood the question. She was explaining the process. If that's the case, great. But if we're just talking about other cases generally or other experience outside of this case, it's sustained. But if it is to explain her method or opinion, why don't you just restate the question?
Sure. Do you know how easy it would be to transfer cotton-type fibers to a truck?
Object to the form of the question. If she's got an opinion to a reasonable degree of professional certainty, that's fine. But if this is anecdotal testimony from personal observations that are not peer-reviewed, we've got a problem with that.
She tested the fibers.
She tested the fibers.
It's sustained.
When fibers are transferred from a garment to another object, you have to take into account the texture of the items in question. So, for example, a fuzzy sweater is going to transfer fibers a lot more easily than, say, a windbreaker jacket. So a t-shirt would be somewhere in the middle. When you're transferring onto a hard surface, there's less likely to transfer a lot of fibers onto a smooth hard surface like a car than it would be onto like a more textured surface.
Does the amount of fibers left behind on an object have any correlation to strength of, let me rephrase it.
Your Honor, I will object to suggest we take this matter up outside the presence of the jury.
What's the objection, Mr. Goff?
Your Honor, if she has an opinion to a reasonable degree of professional certainty, I have no problem with that. But this is a fishing expedition. I object to it. I'm just looking, and I'm basing that based on the report I received in this case.
As long as she needs to present a foundation, you can testify as long as there's a foundation. Go ahead.
Are you able to determine how long an object was on another object based on the amount of fibers left? Generally science-based.
I cannot determine with absolute certainty how long items were in contact. I can say that the longer that items are in contact, the more likely there is to be more fibers transferred.
Let's talk about the second analysis you did. Okay. What was that second analysis?
I was asked to perform a general materials analysis, which is basically the identification of an unknown material.
Okay. And where did that material come from that you were asked to analyze?
It was identified as coming from the armpit of the body.
And the body of whom?
Of Ahmaud Arbery.
And what analysis did you perform, and what were your results?
I performed, so I examined the material using our stereo microscope, our low-powered microscope, and also a higher-powered microscope. I also analyzed it using the instrumental technique I mentioned before, FTIR, to look at the structure of the material. And I found that it was characteristic of botanical material. So this is plant material. It can be things like wood or bark or leaves, pine straw, that type of material.
And where did you receive this material from again?
This material was received from our medical examiner's office.
And once you're done with your analysis of any case that you get in, okay, once you're done, does it go through a secondary process to determine whether or not you believe that it was accurate and that sort of thing?
Yes, every case it goes through a peer review process, so a second examiner will look at all of our notes and data and our report and make sure everything supports the findings.
And was that done in this case?
It was.
And do you believe that you followed all your standard protocols and procedures when it came to both of these analyses?
I did.
And once you're done doing the analysis, do you document your findings in some sort of report or notes?
Yes, I have notes for the case file that we retain in our computer system, and then I will issue a report on the matter.
And did you do that in this case?
I did.
And for the purposes of the record, what is your case number for both of your reports?
The case number is 2020-6001183.
Just one moment. Ms. Kissarow, do you happen to know where that botanical matter came from?
It was identified to us as having come from the...
You said the armpit was
the left armpit area.
Okay. But before that, you don't know where it came from?
No, I do not.
Judge, at this time, the state will pass the witness subject to redirect.
No, Your Honor.
No, Your Honor.
Yes, Your Honor.
Good afternoon, young lady.
Good afternoon.
My name's Kevin Goff. I represent Mr. Bryan. I have just a few questions for you.
Okay.
A moment ago, did I hear you tell the jury that, that you can't say definitely that the cotton fibers came from the shirt attributed to Mr. Arbery?
That's correct.
Okay. But your report doesn't say, that's not the words in your report, are they?
I reported out that I could not eliminate these fibers as having come from the shirt.
Okay. Well, would you not agree there's a huge chasm between the words in your report about you can't eliminate the possibility that the fibers came from the shirt to today when you say that you can't say definitively that they did come from the shirt? Those are conclusions in two completely opposite directions, aren't they?
Well, no. So I can't eliminate those as having come from the shirt. That is also true that I can't say they absolutely did come from the shirt. Those are not exclusionary of each other.
Logically, they're not, but they certainly convey different ideas, don't they?
I hope that I have conveyed properly the idea that I cannot eliminate these.
And, of course, you examined fibers that were identified as having come from the driver's side of truck, correct?
Yes, that is what they were identified to us.
You were
as.
not asked to examine or compare any fibers recovered from either the front or the back of that truck.
To my knowledge, no other fibers were recovered.
Okay. Now, sheet metal is a smoother surface,
That's correct.
I believe that's what you were referring to earlier.
Yes.
What about grills? Are they all smooth?
They have a smooth surface. Potentially things could get caught in areas of a grill.
Hood ornaments, also not smooth.
They do have some sharper edges.
Bumpers have sharper edges.
Again, depending on the area.
Back bumpers have sharper edges.
They can.
Okay. So in the end, I think, correct me if I'm wrong, what you've told the jury, essentially, stripped of everything else, is that these fibers may or may not have come from Mr. Arbery's shirt.
They are consistent in all their properties. They could have come from this shirt, but they also could have come from another source possessing fibers of the same characteristics.
All right. Thank you, ma'am. No further questions.
Any redirect from the state?
No, Judge.
Thank you, ma'am. You may step down. She also subject to recall?
No, Judge, we're okay on that.
All right. You are released. Thank you, ma'am.
I thought we were keeping all the witnesses subject to recall.
If you want her, we can keep her, but
We'll keep her subject to recall.
She just walked out the room. We'll make sure someone gets her the message.
we know where she works.
We can find her. Okay. Ladies and gentlemen, we're a good place to break for lunch. We're going to take a 1-hour recess. Enjoy your lunch. We'll see you back here right about 1 o'clock for a continuation of the evidence in this case.
All right for the jury.
All right. Anything from the state before recess?
No, Judge, nothing from the state.
From Travis McMichael.
No, Your Honor.
From Greg McMichael.
No, Your Honor.
From Mr. Bryan.
No, Your Honor.
We're in recess until 1 o'clock.
Thank you.
will be the 3 o'clock march into the community. I just want to say to all the black pastors and our allies around the country, come here. The judge was right today in rebuking the defense. The judge was right today in saying that the comments by Mr. Goff about comparing an icon, a civil rights leader of sacrifice like Reverend Jackson, to Colonel Sanders and men in white masks, when we know the history of who wears white masks, comparing, I think the judge was right in saying that those comments were reprehensible. His word. His word. And we also support what he said when he said that, Reverend Jackson, that the statements of Mr. Goff created the environment that is here today. When he said, not only did he say he created the environment, he pointed out that his other defense counsel, Mr. Sheffield, said what? Come one, come all. After calling Mr. Goff's comments asinine. You know, I just wanted to be clear. People have said to me and everybody else, you know, this case should not be about race, but they made it about race.
That's right. That's right.
They made it about race.
Right.
And we just want to be clear that the continued attacks on the banner of the Transformative Justice Coalition as one of the co-leaders of the Transformative Justice Coalition, I really find that, you know, absolutely not only absurd that he continues to attack us, but if my co-leader, Mr. Attorney Darrell Jones, was here, he would also point out that the First Amendment is foundational. We have the right of peaceful assembly.
That's right.
The right of freedom of expression.
That's right.
We have a right, just like you do, of freedom of the press.
That's right.
And we have a right. Whoa, I mean, come on, everybody. He keeps talking about how many pastors can they have? How many pastors can they have? We have the right of freedom of religion. And people, and I wish every single American could find it in their hearts to pray for the Arbery family. Every single American could say deep in their hearts that I want justice for Ahmaud. That we believe that we stand here not just out of some self-interest, but we stand here for the interest of all of humanity, just like Reverend Jackson has done throughout his life. And that's why it is so important to us that he will be with us all week long. All week long.
I think that
Go ahead, Reverend.
The acts of attacking Reverend Sharpton, attacking my presence, in the weak case, look at the strong diversions.
Yes.
3 men killed an innocent unarmed boy.
Yes.
Come on. And the neighborhood witnesses who saw it. They have a weak case.
Yes.
Come on. They want a mistrial. The judge said you'll not be granted a mistrial.
That's right.
Look at the diversion. To me, the burden is not just ethnic; it's also ethical. Not just black and white, but wrong and right. I think that the ethical issue is that this community wants to, the community that we're in today, want to be the sanctuary for killers, sanctuary for development. And I think that here's 9 white women in the jury, 1 white man, 1 black man. Do you think our president would influence white women to vote one way or another? Is a bit absurd. But if you flip the script, 11 black jurors and 1 white juror.
Okay.
Black judge, black prosecutor, black defense lawyers. And you eliminate the 7 white jurors based upon that's do you know where Abraham Lincoln is? Do you know what you say, If they flip the script, that is anxiety. Says about the makeup of the jury, but yet there's a decency factor in this sound. They're afraid of the decency factor rising up. Yes, there's a new Georgia, there's a new America. I grew up in the South. I didn't know what was new about the South. And when I look at it and I see Georgia and Georgia Tech playing the big game, Georgia Tech versus Bulldogs. Skin color, not skin color. We're growing up. So Georgia won for Joe Biden last time around, contrary to Trump's opinion.
Right.
He grew up south of the thing. Any questions before we go?
Yes, any questions from the media?
Reverend, last week you were misidentified by defense attorney Kevin Goff. Today, you heard different language, but essentially the same motion, the same concern was raised in the room. What was the reaction hearing those defense attorneys essentially call for mistrial because of your presence today?
I've been called other names other than Jesse Jackson. Honor me by making my name famous. I mean, the reality is this guy, this is the version.
Right.
He has no constitutional right to who's in the court. I'm a good citizen, constitutional right, and moral obligation.
Yes, sir. Will you continue to be in the court for the Ahmaud Arbery family going forward for this week?
I expect to be. And beyond. We're not,
Yes.
we're not going to turn this
Right.
loose.
That's right. That's right.
That's right.
This is one of the immaterial, I think, Jelanda Day and Illinois.
Speak.
This case represents the kind of immaterial of our day.
Yes.
I asked Ms. Rosa Parks, I said, Ms. Parks, why didn't you go to the back of the bus? I said, 3 other women, she said, got off. She said, well, Reverend, she said, one reason is that I thought about immaterial, I couldn't go back. Besides, Fred Greer and I met every Wednesday, test the 51st decision. She was not some idle watcher. She meant to sit in, driven by the emotions of Emmett Till and the legal work of Thurgood Marshall and Constable Baker Martin in that group. In some sense, the Arbery case is so blatant, so open.
That's right. Come on.
Yeah,
That's right.
Yes.
That's
Come
right.
on.
Anybody be jogging with me.
Come on.
Jogging with
Come
me.
on with
It could be you.
Come on.
Right.
Come on.
What based on misbehavior, drunkenness,
No.
in the fight?
No.
Alone.
None of that.
No.
Heinous crime against humanity. Yes, ma'am.
Reverend Jackson, I know you've been in major trials like this before. This is not your first rodeo. Do you see Judge Walmsley possibly acquiescing to Mr. Goff as this continues on, or do you see him standing his stand?
The judge was saying in my judgment. The thing I'm concerned about, from afar, 11 white jurors, 1 black juror, from afar. Look at those jurors, I don't have the same reaction to them. I sense there's a streak of fairness in them. Of course, in the case of Emmett Till, one juror could have passed the whole thing. It's true here too. So the jury is important that they hear good information and be the verdict. A healer, reconciler.
Amen.
Amen. I've been working home from foreign jails. I believe in conflict resolution. But all winners as opposed to all losers. That's who I am.
That's right.
I've been jailed 62
Yes.
years ago.
Yes.
Trying to use public accommodations.
right.
And using the library. Greensboro, trying to use public accommodations. So I've been facing jail and all this a long time. It was about we have that qualified lawyers, black and white together.
Yes.
Stand together.
Yes.
And for just, I think this issue will come under ethics, not just ethnicity. Wrong and right, not just black and white.
Thank you.
Reverend Jackson, the defense lawyers are saying that you're trying to influence the jury. What is that's the specific charge that they're saying, that you and the other pastors are trying to influence the jury.
I'm saying with the family. I don't know the jurors. I don't know any of them.
Right.
That's right.
Right.
Come on.
Right.
That's right. Come on,
I
Rev.
don't know
Tell
any
them,
of
Rev.
them. If my president sends to affirm the innocence, victimhood of a young man who was killed, I sent for him, for his family. I think 3 men, him who was born killing him is just wrong.
Yes.
Come on. Wrong.
Huh? I was telling the mother, hold on, that she's winning.
Yes.
So she should accept the fact he was crucified. We couldn't stop the crucifixion. They can stop the resurrection.
All right.
Easter story is that innocent people are killed. You can't stop from crucifying, they can't stop God from resurrecting.
Come on.
He's bigger than he ever was in life. He's all over the world now. In London, France, South Africa, Mississippi, New York. He's on the stage now. There's power in the blood of innocent people. There's power in the blood of innocent people.
We have shown you the defendant murdering Joseph Rosenbaum from 3 different angles. The drone footage, Drew Hernandez, and also the FBI video. The defendant admitted that during this entire incident, he knew that Joseph Rosenbaum was unarmed. I'm going to come back to this in a little while, but there's this alleged threat that Mr. Rosenbaum made earlier in the evening to kill the defendant. I will debunk that. That did not happen. It is the one fact in this case the defendant wants you to believe that there's no video of.
very high rates of speed out on the freeway. Right now we're on the 118 freeway, traveling westbound. It's the westbound side of the 118 freeway, and there's not
Let's continue, Mr. Vinger.
Thank you, Judge. Good afternoon, ladies and gentlemen. I'm going to continue on. I hope your full stomachs won't distract you too much from the presentation here. So I had been talking about the murder of Joseph Rosenbaum. And as you can tell, I'm trying to go in chronological order. I'm trying to go through these events in a way that makes the most sense. So count one of the information is with regard to Joseph Rosenbaum. The second count of the information pertains to Richie McGinnis, who you heard testify. He testified that he was in the line of fire behind Joseph Rosenbaum as the defendant fires 4 rounds with his AR-15, which is loaded with full metal jacket ammunition. And I'll talk a little bit more about that type of ammunition in a little bit. But you've heard testimony that it's the type of ammunition that is capable of going through body armor. It is capable of going through a squad car. It is designed to go through the target and continue flying on for up to 550 yards. Richard McGinnis testified that when those shots went off, he thought he had been hit. He thought his life was in danger. One of the rules that I think most people who are familiar with firearms knows is always check your background, meaning know what's around your target and know what's behind your target. This is true when you're hunting, it's true when you're target shooting, and obviously it's true when you've got an AR-15 in downtown Kenosha in the middle of protests with houses and people nearby. But there's no indication the defendant cared one bit about his background, cared one bit about where those bullets were going to go. And as I said, he put Richie McGinnis in danger. Richie McGinnis, after this incident you've seen on the videos, goes to try and help Joseph Rosenbaum, and has his own video shows when he first gets there, he finds Mr. Rosenbaum's body face down on the ground. And I'm going to play this exhibit 15 for you.
You okay? Just don't move, man. Don't move. All right, can I flip you over real quick? Oh, I'm gonna flip you over real quick, bro. Flip over real quick. Just gotta get pressure on this, dude. Where's it at? Where's it at, dude? Get a light on it. Get a light. Give me a fucking light. Where? Where, dude? Where? Where's the hole? Get the fucking light up. Come on. Put pressure. Put pressure. Keep your eyes open. You shot him. I didn't let go. Dude, that's just the pressure on this shit. We gotta keep alive. I got it. What's your name, man? What's your name, man? What's your name, man? Is y'all thinking the hospital right here? Get him out. Get him out. Start crying. Yo, keep pressure on him. I got him. Get him. Keep pressure on him. Get his arms. Look at now. I got you.
You want to talk about medics, you want to talk about people who care, you want to talk about people who are there trying to help. You just heard them and you just saw them. People who didn't know Joseph Rosenbaum, they just knew somebody needed help. And while that's going on, the defendant flees, callously disregarding the body of the man that he just shot and killed. And as he's running off, he's lying to the crowd about what just happened. This is exhibit number 12.
So there was just like 6 shots. It went off.
The defendant says he pulled a gun. That statement, he pulled a gun, was a lie. It's not true. The defendant knew it wasn't true. He's lying to the crowd as he's running away. Joseph Rosenbaum didn't have a gun. The defendant knew he didn't have a gun. The defendant is lying to save his own skin instead of going and trying to help the person that he has just shot and killed. In exhibit number 3, Gage Grosskreuz's Facebook Live video, he tells a similar lie. As they're running, Mr. Grosskreutz asks the defendant, "Did you just shoot someone?" And the defendant says something about the police and then says, "I did not shoot anyone." And this is similar to the lie that he told Jason Lukowski at exactly that same time. As he passes Mr. Lukowski, he says, "I did not shoot anyone." And that was established through Mr. Lukowski's testimony. And again, I think it's worth emphasizing at this point that Jason Lukowski had just met the defendant maybe an hour. This is about 11:50 at night. Mr. Lukowski got there about 10:45.
Almost.
This is Gage Grosskreutz running towards danger, running to try and help. This is exhibit number 3.
Hey, what are you doing? You shot somebody? Who shot? Who shot? Hey, what are you doing? You shot somebody? Who shot? Who shot?
Listen to the second thing he says.
You shot somebody? Who shot? Who shot? Hey, what are you doing? You shot somebody? Who shot?
It's hard to tell what his exact words are. I hear the word "not" pretty clearly in there, as in I did not shoot anyone, I did not do anything. Jason Lukowski, he lies to. The crowd, he lies to. Gage Grosskreutz, he lies to. So at this point, the crowd is dealing with what they perceive to be an active shooter. Someone who has just shot someone, who is still in possession of the gun, who is fleeing the scene, and how are we supposed to know where he's going next? You know, all night that night, the crowd has been hearing the sound of gunshots. They've been hearing fireworks, firecrackers. But now, someone actually has been shot. The crowd sees the defendant running with a gun. He's lying to them. He still has the gun. He's shot someone. This is provocation to them. This is someone who has committed a criminal act and is putting people in danger. It is entirely reasonable for that crowd to believe at that moment that he is a threat to kill again. The defendant could have made it unequivocally clear what he was doing. He could have stayed at Mr. Rosenbaum's body, helped protect him, helped preserve his life, call 911. As he's running, he could have announced to the crowd exactly what he was doing, told them. He could have fired warning shots to try and keep him away. He could have dropped the gun. He could have raised his hands in surrender. He could have signaled to this crowd that he did not pose a threat anymore. But everything he does is indicative of someone who is still a threat. Now, the defendant is going to tell you he wasn't. But from the crowd's perspective, how are they supposed to know any different? He does nothing to demonstrate to the crowd that he isn't a threat to kill again. And it turns out he does. It turns out within a few seconds, he does kill again. I submit to you, ladies and gentlemen, that in this situation, the crowd has the right to try and stop an active shooter. They have a right to protect themselves. The defendant is not the only one in the world who has the right to self-defense. But what does the crowd do to try and stop the defendant? I submit to you, and this is not a criticism of them, but they use almost the least minimal, least intrusive means possible. They could have used deadly force against him. They could have shot at him. But instead, somebody comes up behind him and knocks his hat off. Anthony Huber comes up with a skateboard and the defendant blocks it with his arm. And then the defendant falls to the ground on his own. No one knocked him down. This man that the defense wants to call jump kick man, he's got no weapons, no gun, no knife, no nothing, comes in and tries to kick the defendant in the face. Anthony Huber comes back and tries to grab the gun, actually does grab the defendant's gun and tries to pull it away because he's trying to disarm an active shooter. And Gage Grosskreutz comes running in, stops with his hands up in the air until he sees and hears the defendant adjusting his weapon as if preparing to fire again. And then what does Gage Grosskreutz do? He reaches for the gun to try and disarm the defendant. Gage Grosskreutz had his own gun in his own hand. He could have aimed it and fired at the defendant, but he did not. And you heard Gage Grosskreutz testify about that, about how that is a decision that he was not prepared to make at that point in time. He is not the type of person who is just willing to take someone's life in an instant, unlike the defendant, who took 2 lives that night, very quickly and seemingly very easily. There is a video, Exhibit 5, which is the BG on the scene video, which traces this entire incident, which we call the second event. This is going to show you Mr. Huber, Mr. Grosskreutz, and the other individuals who are trying to stop an active shooter using what I would characterize as the least intrusive means possible. Someone knocks his hat off. Anthony Huber comes in with a skateboard. In just a few seconds, the defendant kills one person, attempts to kill 2 more, and blows off Gage Grosskreitz's arm. It's that fast. This is someone who has no remorse, no regard for life, only cares about himself. And these folks that are coming at him, the jump kick man, Anthony Huber, aren't armed. They're not a credible, imminent threat to his life. They are trying to stop an active shooter. And they have a right to do so. Imagine if the crowd couldn't do that. Imagine if they weren't allowed to try and stop someone in this type of situation. After killing Anthony Huber, after severely wounding Gage Grosskreutz, the defendant walks away like he's some sort of hero in a Western. Without a care in the world for anything he's just done. You know, it's interesting. This occurs about a block away from the police line, right down the road. If the defendant's so concerned about his safety, the police are right there. And in fact, they pull up to this scene almost instantly. The defendant's got his medic bag on. He proclaims himself a medic. He doesn't know at this point if Anthony Huber's dead or alive or capable of being saved. And yet the defendant offers no assistance, makes no attempt to try and help anyone else. All he cares about is himself. We have taken that video and we have broken it down into individual frames. And I want to take you through, frame by frame, the incident with Gage Grosskreutz. Because a lot has been made about Mr. Grosskreuz's motions and what he does and where he goes and things like that. So I think it's helpful for us to take a look at this. So this is Exhibit 80, beginning with frame 356. At this point, you can see that Anthony Huber is staggering off after being shot in the chest. The wound has entered his lower left rib cage and has wound up almost exiting near his right shoulder. It has ripped through his ribs, his heart, his aorta, and he may not technically be dead, but he's going to be dead within a few seconds. He is stumbling away. The defendant has the weapon pointed towards Gage Grosskreutz here, who is cowering, hovering, hiding, covering his head, trying to stay out of the way. And I'm going to go frame by frame here slowly as we see the movement. Now we see the gun is moving down towards Gage Grosskreutz. It is pointed directly at him from a distance of just a couple of feet. Gage Grosskreutz has his right leg planted as if he's pushing backwards, trying to get away. The gun is still pointed at him. The defendant here is going to adjust the gun, turn it over as if he's making some sort of adjustment on it. Gage Grosskreutz testified that this was a movement that he interpreted as the defendant preparing that gun as if it was going to fire again, as if clearing a jammed round so that he could shoot it at Mr. Grosskreutz. At this point, Mr. Grosskreutz is, I think, probably thinking to himself, if I can get away, I will, until he realizes that the defendant is getting ready to fire again. In none of these frames is Mr. Grosskreuz's right hand with his Glock pistol pointed at the defendant. You can see Mr. Grosskreutz is actually backing up with his right leg. Let me go back a couple of frames here. This is frame 444. You can see his right foot is on the ground, but it's starting to move back. Now as I move forward in the frames, 447, his right leg is moved back. This is someone who is about to retreat. His hands are in the air. He's backing away from the defendant until, as he's testified, he sees the defendant start to manipulate that gun in such a way that it makes Mr. Grosskreutz feel like he's about to be shot. And only then does he take action. What action does Mr. Grosskreutz take? Does he hold that gun with both hands, the Glock that he's got, and point it at the defendant? No, never. Does he even take the gun with one hand and point it? No, never. Instead, you can see him start to lunge in with his left arm forward. The gun is not in this hand. The gun is in his right hand. He's lunging forward, reaching for the defendant. Probably reaching for the gun. Probably trying to block the gun. You can see now he's going to take a step with his right leg across the defendant's body. Not directly towards the defendant, but across the defendant's body. As he's reaching in, almost swiping away at that gun with his left arm. He has bladed his body in such a way as to try and present as minimal of a target as possible, which is probably what saves his life. His right leg is about to hit the ground here. The gun, the AR-15, is pointed directly at him from just 2, maybe 3 feet away. He's trying to shield himself with his left arm. And as we approach frame 500 here, the gun goes off. At no point in this process is Mr. Grosskreutz pointing his gun at the defendant. Frame 499, the gun is just fired. Frame 500, you see the puff of smoke. 501, the bullet has hit Mr. Grosskreuz's right bicep, severing it. I'm going to continue forward after this because you can see that his right arm, this is an interesting frame right here, 504. You can see that gun. I'll go back even more. You can see that Mr. Grosskreuz's arm with the right hand, with the gun, his right hand is pointed off to the side. What pulls that gun down closer to the defendant is the fact that Mr. Grosskreutz just had his right bicep severed. It's not a voluntary action. It's an involuntary, the muscle is severed. Now watch, frame 502, watch his right hand. 503, 504, 505, 506, 507, 508. At this point, yeah, absolutely. That right arm is probably dangling down towards the defendant. It's not going to be able to pull that trigger without a working bicep muscle, and it's not a voluntary thing. It's done because the defendant just blew his arm off. But yeah, this is the time after the shooting when, yes, the gun happens to be pointed at the defendant. And I got to stop here for a moment and highlight the hypocrisy of the defense. Because according to the defense, if someone has a gun, they're a threat. If someone points a gun, they're a threat. There's only one exception to that. The defendant. By their logic, he gets to run around with a gun all night. But, oh, we're not supposed to take him as a threat. He gets to point the gun at everyone. But, oh, we're not supposed to take him as a threat. No, it doesn't work that way. The same set of rules apply to the defendant as everybody else. There's no exception in the law for Kyle Rittenhouse. There's no exception that says, if anyone else has a gun, you're a danger, except for Kyle Rittenhouse. There's no exception in the law that says, if you point your gun at people, oh, that makes you a threat and I can kill you, except for Kyle Rittenhouse. I can do it all night long. The same rules apply to him as everyone else. And everyone else has a right to defend themselves also, not just the defendant. We have shown you photos and videos of Gage Grosskreuz's injuries. Exhibit 60 is a video taken right after Mr. Grosskreutz was wounded by the defendant. It's hard to look at, but this is what we're dealing with. When you fire an AR-15 at someone from close range, this is what it looks like. I guarantee you, ladies and gentlemen, the defendant had no clue what his gun was capable of. He didn't even bother to pay any attention to it, didn't concern himself with what he would be doing to other people. But this is what happened. Let's not flinch away from this. It's important that we understand what that gun was capable of that night. It killed 2 people, and it did this to Mr. Grosskreuz's arm. When those shootings occurred that I just played for you, what would a reasonable person in the defendant's position at that time think? The good news is, ladies and gentlemen, you're going to tell us. As part of your decision in this case, you will represent the reasonable person, of ordinary and prudent person, and you will put yourself in the defendant's shoes that night. I submit to you that at the time of those shootings, a reasonable person in the defendant's shoes would have known that he had provoked Joseph Rosenbaum by pointing his gun at someone else, that the defendant had put someone else at risk of dying by doing that. The defendant should have known that the crowd was aware of the fact that he had just shot someone and that they felt their lives were in danger. That is reasonable. It is also reasonable to understand that at that point, Gage Grosskreutz had just witnessed all of this. He had heard the defendant had shot someone. He'd heard the defendant lie about it. He saw the defendant shoot at Jump Kick Man at close range, miraculously missing. Had seen the defendant kill Anthony Huber. Gage Grosskreutz reasonably believed his life was in danger at that moment. And he was proven correct, because the defendant shot him too. So when you consider what's reasonable in this case, consider whether or not it's reasonable for a criminal to be able to shoot himself out of a crime scene. When a bank robber robs a bank and runs away and the crowd comes after him, can he just shoot anybody and claim self-defense? If someone comes up to that person and tries to stop them, tries to disarm them, like Anthony Huber did, do they forfeit their life? Did Anthony Huber forfeit his life by trying to be a hero and stop an active shooter and protect others? Is that justified? Can the defendant just kill him? In this case, the crowd was right. The crowd knew the defendant had just shot someone. When they're coming after him, they know he's just shot and killed Joseph Rosenbaum. But you know, not every active shooter situation is the crowd have perfect knowledge. When they're told that person running up the street just shot someone, we don't have time in the moment to go back and take a look at the body and replay the video and make a decision before going after the person with the gun. You know, we've had several police officers testify that in an active shooter situation, their first instinct, their first training is to go in and stop the threat. They don't sit there and wonder, well, maybe it was self-defense. I don't know. I'm going to, wait and see. And every day we read about heroes that stop active shooters. That's what was going on here. And that crowd was right. And that crowd was full of heroes. And that crowd did something that, honestly, I'm not sure I would have had the courage to do. If I see a guy running up the street with an AR-15 and I hear he just shot somebody, my first instinct is not to approach. Anthony Huber was different. Jump Kick Man was different. Gage Grosskreutz was different. That doesn't make them a threat to the defendant's life. It doesn't make their lives worthless. They don't give up their right to defend themselves. They have just as much right as the defendant. I told you I wanted to begin by talking about the murders committed by the defendant. Now I want to go back and put it all in context for you. And that context starts with, bruh, I'm just trying to be famous. The defendant's TikTok profile. 4 doors, more whores. Picture of him up in Ladysmith, probably in early May, proudly holding his new AR-15. Up until August 25th, 2020, this is the only time he'd ever fired that gun. Maybe put 100 rounds through it or so at that property up there with Dominic Black. They purchased that gun on that same trip. The defendant admitted he knew as a matter of law he could not buy that gun because he was only 17. Yet he wants to tell you that he thought legally he could possess it, which didn't make a lot of sense to me. We don't have a lot of defendants come in and say, well, I possess cocaine. I knew I couldn't buy it, but I thought I could possess it. It's not the way it works. Dominic Black conducted what we call a straw purchase for the defendant. He purchased that gun for someone who was not legally allowed to purchase it for themselves. I'm prosecuting Dominic Black for that, as you know, just like I'm prosecuting Joshua Zeminski. Because what Dominic Black did was wrong, and we don't tolerate that. The agreement was Dominic Black was going to keep that gun until the defendant turned 18. It was Dominic Black's gun. It was legally his. And the defendant knew that it was going to be held onto until he turned 18, that he was not going to have it until that birthday. I want to focus a little bit on this AR-15 because I think it's important when you consider the recklessness of the defendant's conduct, how much he knew, cared, or didn't know about this deadly weapon. He'd only fired it that one time, maybe 100 rounds through it. He loaded the gun with full metal jacket ammunition, which I'll talk about a little bit more. He wanted it because he said it looked cool. Didn't seem to know or care much about the type of ammunition or the type of gun. You had a couple of witnesses tell us in this trial, and I could not believe it. A gun is a gun is a gun. Don't even start with that. And a bullet is a bullet. No, it is not. It is not. And anybody who says that is ignorant and reckless, because there are some important distinctions here. Full metal jacket ammunition is capable of piercing body armor and squad cars. And you heard Officer Krieger testify that when they heard someone was running around with a rifle, he went and got his plate armor out of the back because their regular body armor wasn't going to stop those rounds. Ryan Balch talked about how full metal jacket ammunition is designed, and this is a former Army infantryman, is designed to go through a target like a deer or a person and continue on. He says it can hit a target 550 yards away. That's 5.5 football fields. And he explained that he had a handgun that night, which he put hollow point ammunition on. And that's what he was planning on using for self-defense. Because hollow point ammunition acts differently. It's going to hit its target, but it's not designed to continue on and go through and hit other targets. So you will hit what you hit, but you're not going to put the rest of the community at risk, especially on a night when there are hundreds of people out on the streets in a heavy residential area. We can see on that map that car source, there are houses, there are churches, there are daycares, there are schools nearby, and you're firing full metal jacket ammunition around. I submit to you, ladies and gentlemen, that that AR-15 had no lawful or legitimate purpose that night. Now, the Second Amendment allows people to carry guns. That is true. There are people who can't carry guns, convicted felons, for example. But, generally speaking, I'm not saying people don't have the right to carry a gun. What I'm saying is that AR-15 did not accomplish any of the goals that these folks said it was going to. So, for example, Ryan Balch says the handgun is what he was going to use for self-defense. Several witnesses agreed you can't point this gun or shoot this gun at people to protect property. So if you're going to protect the car source building, how is this gun going to help with that? The defendant has admitted the gun was useless when he was going to treat people as a medic because it got in the way. He had to take it off and hand it to someone. So you can't use it as a medic. You can't use it to protect the building. So what's it there for? Well, it looks pretty imposing, and it has some deterrence value, but Jason Lukowski, Dominic Black, and Ryan Balch all said they never actually intended to use their guns. So why is it there? The defendant was wearing a sling that night. He purchased that sling at Jelinski's that afternoon. The purpose of the sling was so the gun couldn't be taken away. Wouldn't fall off, he wouldn't lose possession of it. It was designed to help him retain possession of that gun. And he loaded it with 30 rounds, the full magazine, capable of killing 30 people or more. Why do you need 30 rounds of full metal jacket armor to protect a building? this AR-15 is completely incompatible with the role of a medic. Richie McGinnis testified he's been to demonstrations in Seattle, Portland, Washington, D.C., New York, Minneapolis. He's never seen anyone walking around claiming to be a medic with an AR-15. And certainly when you see someone like that, it doesn't exactly send a warm, fuzzy message. Oh, come to me, I'm here to help. And the defendant acknowledged he had to take off his AR-15 to treat people. No serious, credible medic wears an AR-15 slung around their body. That's because the defendant was a fraud. He was not an EMT. He lied. He lied to the press. He's being interviewed by Richie McGinnis, who he hears is a member of the media, and he says, I'm a certified EMT. You're lying. You're absolutely lying. Jason Lukowski and Dominic Black said the defendant had to borrow his medical supplies from us. This is an emergency situation. Everybody's anticipating violence. Everybody's prepared for people to be hurt, harmed, injured, and yet the defendant's going to go there and walk around claiming to be a medic? He's like a quack doctor practicing without a license. That puts lives at risk. And one of the things I had Gage Grosskreutz testify about is that tattoo on his right arm which said, "First, do no harm," which is one of the precepts, one of the fundamental tenets of the practice of medicine. First, do no harm. So how do we evaluate the defendant's performance as a medic that night? Well, on one hand, he wrapped up an ankle and I think maybe helped somebody who got a cut on their hand. Yay. On the other hand, he killed 2 people, blew off Gage Grosskreitz's arm, and put 2 more lives in jeopardy. So, you know, when we balance your role as a medic that night, I don't give you any credit. He showed no remorse for his victims, never tried to help anybody that he hurt, and even on the witness stand, when he testified on Wednesday, he broke down crying about himself, not about anybody that he hurt that night. No remorse, no concern for anyone else. For him to call himself a medic is an insult to anyone like Gage Grosskreutz, who spent hundreds of hours training and working hard to become an EMT. It's an insult. The defendant made a series of reckless decisions that night, going armed with an AR-15 at 17 years old when he knew he shouldn't have done so, because that gun is normally locked in a safe that he doesn't have access to, and it's not even legally his. He's out after a citywide curfew. He's intentionally and knowingly entering into a dangerous situation, and he expects it because he brings along his AR-15 and some body armor. So don't tell me you didn't know. He brings along no non-lethal means of defense, which means his only option is to kill. I don't know about a lot of you, but I remember that night. I didn't come down here. I don't think most reasonable people did. In part because we all knew it was going to be violent and dangerous. Most reasonable people, to the extent they came out, they were gone by then. Because you don't willingly put yourself in this situation unless you want it, unless you're looking for it, unless you want trouble. Now, to put this in perspective, at this time here in our community, there were people who were scared. There were people who were worried about themselves, their homes, their families, their business. That's understandable. But this is different. There are also people out there who were exercising their First Amendment right to assemble and to have free speech because of whatever they believed in. And they have that right too. But that's not what we're talking about. The curfew, the riots, the arson, the looting that we'd seen on those prior nights, roadblocks set up around downtown, closed exits on the interstates, all of this was sending the message to reasonable people, go away. Don't come down here. Who was left at 11:45 at night? Most reasonable people had gone home before the curfew, or never even came at all. But the defendant's down there, he says, because he wants you to believe he's protecting CarSource, even though he had no actual ties or genuine concern for this building. You have this caravan of people from West Bend, Ryan Balch, Jason Lukowski, Joanne Fiedler, coming down from some other community, having no idea what's going on here at Kenosha, having no idea what businesses are, having never dealt with CarSource before, just injecting themselves into this situation. CarSource that night was empty. The owners testified. They moved all the cars off the lot. They took the tools out from inside, and they didn't even feel the need to protect that building. So who's there? These guys with their AR-15s are just wannabe soldiers, acting tough, trying to manufacture some personal connection to this event, furthering their own personal agenda. Just a small part of the deluge of chaos tourists we saw here in Kenosha, trying to feed off of what we were going through. Despite everything we did to try and tell them, go away, stay out. Did those owners, Sam and Sal, ask anyone to protect their business? You know, I called them to the stand because I wanted you to hear from them. I had their statement, but I wanted you to hear from them. And I'm sure you formed your own impressions about them. I'm not here to tell you that I believe what they said on the witness stand. I don't think it really matters much, except I wanted you to have a flavor of who these people were and what was going on at that building. What was interesting to me is that text message from the defendant to Sam asking for the address of CarSource, even though the defendant says he's already been there. That didn't make any sense to me. It's not hard to find if you've driven past there every day. You know, Kenosha is one of the easiest cities in Wisconsin to navigate. It's all east, west, north, south. How hard is it to find this place? But the agreement was the defendant was supposed to stay at the 59th Street location. There's another group at 63rd. It was their responsibility. And the defendant testified that when the shootings occurred at 11:45 or 11:50 at night, he didn't even know if that other group was still there or if they'd left. But crucially, you heard the testimony of Kriston Harris, who was out there reporting for his Rundown Live, and he's making some video. And he tells the defendant, stay on your property. Don't go out in the streets and engage with these protesters because you're just making it worse and you're escalating the situation. He tells the defendant specifically that, just 20 minutes before the shootings. Kriston Harris probably said that because he knows this is a crowd that is feeling threatened by the defendant and his group. Richie McGinnis testified when he left the Stella Hotel and immediately ran over to 59th Street, he saw guys up on the roof and he felt threatened. These guns, he said, were the thing that changed the dynamic for him. Drew Hernandez, we showed video of Drew Hernandez having laser sights pointed at him. And he said he felt threatened. He thought someone was pointing a gun from the roof and putting his life in jeopardy. These are two people who are veterans. They've been to protests in Seattle, Portland, Washington, D.C., New York. They've been through this before. And yet here in little old Kenosha, the defendant's group made them fear for their lives. That's the kind of impact these AR-15s had. The crowd is yelling at the defendant's group, stop pointing your guns at us, stop pointing these laser pointers at us. And the defendant sees this. He's well aware of the fact that the crowd out on the street is hostile. They don't react well to him. And he knows that by 11:35 at night, this crowd is all the way down there south of 60th. That's where they're at. So if I go down there, I need to be prepared and I need to expect that these folks are not on my side. Joseph Rosenbaum. He's dead, so we don't know what he was thinking. We don't know what was going on in his mind. That makes him an easy target for the defense today because they can stand up here and pile on him and destroy his reputation, and he can't speak for himself. That happens a lot in homicide trials. Blame the victim who can't speak for themselves. So I'm going to tell you a little bit about Joseph Rosenbaum, and you've heard some testimony about him. He had been in the hospital left it that day, had a clear plastic bag with his possessions, toiletries, a water bottle. We've all seen this. You get it in the hospital. It's pretty common. He's walking around like it's pretty much his only possession in the world. He visits Carrie Ann Swart, his girlfriend, and then happens to wander downtown into the middle of civil unrest. No indication he planned to be there. No indication he's part of any sort of movement. He just happens to stumble into it. So what does he do that night? Oh, let me tell you all the awful things Joseph Rosenbaum did. He tipped over a porta potty that had no one in it. He swung a chain. He lit a metal garbage dumpster on fire. Oh, and there's this empty wooden flatbed trailer that they pulled out in the middle of the road, and they tipped it over to stop some bearcats, and they lit it on fire. Oh, and he said some bad words. He said the N-word. If he were alive today, like Joshua Zeminski, I'd probably try and prosecute him for arson, but I can't because the defendant killed him. But that's the way we deal with people that do these things. When you commit arson, we prosecute you. We don't execute you in the street. And I'm not here to say that the things that Joseph Rosenbaum did were good or that I condone that kind of behavior. Not at all. But he didn't deserve to die for it. You can't kill someone for these things. He's 5'4", 150 pounds. Jason Lukowski characterized him as a babbling idiot. Lukowski says, I turned my back and walked away. This guy wasn't even a threat. I think we all know somebody like Joseph Rosenbaum, the Napoleon complex, the little guy who just wants to chatter, but when it comes down to it, it's all bark. It's no bite. It's like a little dog. Bark, 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 but really ain't gonna do anything. There is no dispute in this record that at no point that night did Joseph Rosenbaum hurt anyone. Never had a gun, never had a knife, never had a bat, never had a club. And in the Drew Hernandez video, that fight at Ultimate Gas that we showed you, he's being shoved around by the crowd like a rag doll. And yeah, he's mouthing off, he's talking a lot, but he doesn't actually threaten anybody, doesn't actually hurt anybody. They're pushing him around like he's a tiny little person, which, frankly, he was. And in the background of this video, you will hear somebody say, point your gun at me, or something like that. That's Joseph Rosenbaum. He's upset because somebody pointed a gun, and that triggers him, which is understandable. I think most of us would be triggered by that sort of thing. And that's what's upsetting to him. But he gets right in the face of people who have AR-15s. Never reaches for their guns, never rears back to punch anyone, never even lays hands on anybody. You're going to watch this confrontation here at Ultimate Gas, and I want you to keep in mind that there's a group of people on one side with AR-15s and a group of people on the other side. And none of the people with the AR-15s feel their life is in danger. None of them shoot their guns. They can handle themselves. The defendant can't. That sound you heard was somebody throwing some sort of plastic thing at one of the stanchions underneath the gas station, and it makes a sound that almost sounds like a gunshot. So add that into the mix. You've got people with guns, loud voices, clear hostility, and the sound of something that, frankly, to me sounds like a gunshot, and yet everybody keeps their cool. Nobody hurts anybody. Nobody fires a gun. And watch how they push Joseph Rosenbaum around like a rag doll. Watch this guy in yellow. He's going to shove Joseph Rosenbaum about 8 feet away. Well, I guess it was a different guy that did that, but they're shoving him around like a rag doll. Nobody feels threatened by Joseph Rosenbaum. He's not reaching for anybody's gun. He's a mouthy little guy. He's a little dog that barks. And you know what he's going to do now? He's going to tell him, hey, I need to go grab my bag. I don't have my bag. So they let him on through. There he is about to reach down and grab his bag off the ground. That's Joseph Rosenbaum. You've heard testimony that he tells people, shoot me, asking them to shoot him. I'm curious how that's a threat to anyone else. He's triggered, as we saw in that video, by people pointing guns at other people, which is reasonable. Most people would feel that same way. And then we get to the crux of the defense, this threat that he supposedly made to the defendant. The defense would love to be able to play you a video of this threat. They would love for you to see it and hear it yourself. This is a night in which there are dozens of people out there, reporters and regular folks who are recording with their cell phones and with other cameras all night long. We have shown you video of almost every minute of the defendant's night from multiple different angles, and yet you have not been shown a single video with this threat. Nowhere. It's not out there. Ryan Balch testified, and we have his transcript. We have his testimony, and what he says is there was an incident in which Dustin Collette had put out a dumpster fire and said something to the effect of, fuck around and find out. And Balch steps in, and he has an exchange with the protesters, and he turns around, and Rosenbaum is right there in front of my face yelling and screaming. And I tell him to back up. And he goes, you know what? If I catch any of you guys, blah, blah, blah. So that's the timing, according to Ryan Balch, right after that dumpster fire. Kriston Harris from the Rundown Live was there, physically, standing right next to Ryan Balch. Not only was he there during the dumpster fire, but he stays with Ryan Balch and or the defendant for the next 6 or 7 minutes, recording everything. And I've played this video for you. It is Exhibit 18, and I played for you a period of time from 1 hour and 22 minutes to 1 hour and 28 minutes. And I asked Kriston Harris, I call him to the stand, and I said, I'm going to ask you 2 questions. Number 1, do you independently remember seeing Joseph Rosenbaum, hearing this threat? And he said no. And then I said, okay, well, maybe you missed it, because, you know, there's a lot going on. So will you rewatch your video for me and tell me, is it in there? And he said, no. This video captures that entire period of time with Ryan Balch and the defendant right there, and there's no threat. There's no Rosenbaum. It didn't happen. The defense desperately wants this because they've got to give you a reason why it's okay to kill Joseph Rosenbaum. And this threat is critical to their case. But it's not there. In exhibit number 3, and I'll play it for you here as I'm talking. Joseph Rosenbaum isn't even visible. Now, I submit to you that even if, I'm sorry, this is exhibit 18, even if there was a threat made, it's still not enough because Joseph Rosenbaum's unarmed and you can't kill him. But the defense has pinned a lot of their case on a threat that didn't happen and they can't prove. It's not on video. It's not there. So I'm going to pull up Exhibit 18, the Rundown Live video, and I'm going to go to that mark.
Kristan T. Harris here at the Rundown Live, and I'm here with a bunch of... Kristan T. Harris here at the Rundown Live. If you are live, share this in all your groups, your forums, start watching, protect... Hey, it's just like the gear, man.
So here's the dumpster fire.
It would be just a fucking stem. I could use a doobie right now.
Joseph Rosenbaum is not in this video. Here's Dustin Collette about to put the fire out.
Hey. Come on, reel in. Don't cause problems when there's none here. Yeah, that's true. Just stay on your property. There's way too many of them. I have to agree with her.
There's Ryan Balch standing right next to Gage Grosskreutz. Joseph Rosenbaum isn't here. And the defendant and his group are being told an important message. As long as you stay on your property, but don't go out there and cause trouble.
I have to agree with her. They shouldn't be on the street. They're just protecting their property. One of the guy's an asshole.
I know, I thought they were yelling at them. I was like,
Oh, no.
Well, we did get it lit up.
One of the guys losing his patience. He should go inside.
Yeah, that's what we're about to send him.
Yeah, if you guys could switch him out.
He's talking to Ryan Balch right now.
He's got a lot of rage. He says the wrong thing. This whole crowd burns the guy's life. Protect your property. They're respecting that. Just keep it there.
This is where Ryan Balch goes and talks to a protester.
He's just trying to protect his property. He doesn't want anything. He has no problem with you guys. He just doesn't want to burn down his shit. I can't blame him. I understand. Hey, your job isn't to be in the street. You gotta stay on your property. That's why you got problems already with people. No one bothering your property. Don't look for trouble or anything. I know you are, but like they got their own medics, and if somebody's close by, take care of them. I know you're just trying to make peace. I get that, but they don't look at it that way. They look at you guys as it's a different. It's as much as you guys are afraid of them before they march down here. I know, but like when the conversations are having. Thanks, guys.
Back away from the business. Back away from the business.
The rest of the video is the crowd being warded off by gas launched by the police. They launched tear gas, which affects the defendant, which affects Ryan Balch, it affects Kristan Harris, and that group all runs alongside the 59th Street car source, away from the street, away from any protesters. At no point in that video do you hear any threat that Joseph Rosenbaum makes. It's not there. Trust me. If the defense had it, they'd play it for you. Now, they want you to believe that that threat is made, and they also want you to believe that it was something that the defendant took into account when he decided to kill Joseph Rosenbaum. One of the questions that occurs to me is, how would the defendant even know who that guy is? Because earlier in the night, Joseph Rosenbaum is wearing a red shirt and a blue bandana. But by the time he's killed, he's got no shirt on. He's got no blue bandana. This is someone the defendant has never even met before. He's one of hundreds of people in the crowd. And yet, we're expected to believe that in a split second, the defendant remembers this guy? I don't believe so. So then, that video that I just showed you leaves off at about 11:35 p.m. The police have moved the protesters south of 60th Street. They've tear gassed the crowd, and there's no protesters left. 59th Street is no longer in any danger. It wasn't much danger to begin with. There wasn't anything left there to protect. But by this point, there's no more danger. As law enforcement comes through, you've heard this video where they tell the defendant and his group, "We appreciate you," and hand him out bottles of water. As long as you stay on that private property, yeah. No one is saying you don't have the right to stay on private property and protect private property. What people are saying, what the crowd is saying, is stay there. Don't go out looking for trouble. The defendant hears this message from the police and takes it the wrong way. He thinks, oh, well, now I'm junior policeman. I can go run around stopping crime. But I asked him and I asked some other witnesses, if the police are there on the scene and the protesters are gone, go home. Why are you still here? Shouldn't have been here in the first place. But why are you still sticking around? And interestingly enough, one of the questions I've always had in the back of my mind is, what's the end game here? When is this crew going to be done and decide that it's time to leave? Well, right after the defendant kills Joseph Rosenbaum, kills Anthony Huber, and comes back, they all flee like rats off a sinking ship. But it's boring at 59th Street. There's no protesters. There's no action. So the defendant decides about 11:35 p.m. to cross the police line and go looking for trouble. He knows at this point he's entering a hostile crowd. He's seen this crowd. He knows what they're like. That's why he has to yell friendly to them, because he knows they're not going to see him and think he's friendly. And he knows he's got to have Ryan Balch with him, some sort of buddy to protect him. And he's immediately confronted by that man with the yellow pants who says, "You just pointed your gun at me." And the defendant says, "Yeah, I did." He admits that. Now, what's interesting to me is they want you to believe this never happened. They want you to believe this guy in the yellow pants made it up or is lying. But he's just standing there by the side of the road, minding his own business, when the defendant happens to walk up to him. Do you think he just sat there and thought, oh, I'm going to make up a lie about this guy on the spur of the moment? Or did it really happen? And is it consistent with everything else you've seen about the defendant? Does he sound like the sort of guy who would point a gun at someone for standing on a car? Does he strike you as the kind of guy that would threaten deadly force to protect property? Because that's what happened. The man in the yellow pants says it happened. The defendant agrees. And then he comes into the trial and says, oh, I was being sarcastic. Like he's a little 17-year-old and he wants to get out of it. Shortly after that, the defendant loses track of his protector, Ryan Balch. So now he's in a position where he knows that he's surrounded by people that consider him a threat. He knows that he's not supposed to go anywhere without Ryan Balch. He knows he's supposed to go back to 59th Street. And he does. He tries. He walks up to the police line. He says, I work there. That's my business. Which isn't true, but whatever. And they won't let him through. Now, Ryan Balch makes it on through shortly thereafter. But the defendant gives up. He could go one block in either direction and make it back easily if he wants to. But he stops and decides, you know what, I'm going to stay here and maybe see what's going to happen. So then he talks to these people with fire extinguishers. And he's going to go down to 63rd Street. And he asks one of them to come along. And they say no. Now at this point, doesn't have Ryan Balch. He knows he's supposed to go back. He knows he's supposed to have a buddy. And yet he decides to go it alone. He decides to run down to 63rd Street or walk down to 63rd Street. Doesn't even know if that other group is still there. Doesn't even know if he's really needed. But he can't wait to take this opportunity to go down and confront people. Because he thinks he's some sort of cop, some sort of law enforcement agent, some sort of junior cadet who's out there with the responsibility to fight crime. Nobody asked him to do that. Nobody gave him the right. Nobody deputized him. Ryan Balch says, the police told me, the crowds, we're going to push them down by you, you're going to deal with them. The Bearcats hand out water and tell him he's appreciated. As he's crossing the police line, they warn him about people throwing rocks. What is the message the defendant takes from all of this? The wrong message. Oh, well, now I've got the power. I've got the gun. I'm going to go confront these bad guys. I'm going to stick my nose in things. So what does he do when he gets down to 63rd Street? The first thing he does, we showed it to you at the very beginning, that drone video, grabs that gun and points it at someone to protect property. Points it at the Zeminskis. Because why? Because they're, what, about to mess with some sort of fire? They're not threatening anyone's lives. He doesn't need to protect anyone. He doesn't need to protect himself. He's pointing a gun because he thinks he needs to protect property. He says he wants to put out a fire, but the first thing he does is drop the fire extinguisher on the ground. His AR-15 isn't going to put out a fire. So why is he really there? And we all agree, you can't use or threaten deadly force to protect someone else's property. You are here to decide whether or not his actions are legally justified, not to buy pathetic excuses that might be given to you. As a teacher, when a student says to you, the dog ate my homework, that's an excuse. It doesn't get you out of the homework assignment. If you panic in a situation that is not reasonable, that is an excuse. It is not a legal justification. If you're 17, if you don't have training or experience, if you put yourself in a situation where you're in over your head, if you're scared, those are excuses. Those are not legal justifications to kill. They do not erase your personal responsibility for your own actions. The court has read to you the instructions in this case. They lay out the law that you should apply. That reading took a long time, and I understand there was a lot to digest. And one of the things that you will have the opportunity to do when you go back and deliberate is read through those instructions yourselves. Because I get that listening to them doesn't always make it clear. But I encourage you to focus on some things when you consider the defendant's behavior in this case. You are told that criminally reckless conduct is conduct that threatens other people's lives and poses an unreasonable and substantial risk to other people. There is no dispute the defendant's activities here threatened other people's lives. He took 2 lives. You know, this is not like a normal murder case. A lot of murder cases we're in here trying to convince a jury that the defendant killed somebody. That's not in dispute here. That's the easy part. The question is, does he get a pass? Do we think that's okay? Do we think what he did was right? That's the question you have to answer. And when you consider whether his conduct was criminally reckless, consider, did it pose an unreasonable and substantial threat to the safety of others? Count 4 charges him with first-degree intentional homicide of Anthony Huber. There is no doubt that the defendant intended to kill Anthony Huber or committed conduct that he knew was practically certain to kill Anthony Huber. That gun was pointed at Anthony Huber's lower left rib cage, and the defendant deliberately pulled the trigger. That was no accident. And when you do that with an AR-15 against someone's body, it is practically certain to kill. We all know this case comes down to self-defense. But there's a high bar for using deadly force in a self-defense situation. The law says that the defendant may intentionally use force which is intended or likely to cause death or great bodily harm only if the defendant reasonably believed that the force was necessary to prevent imminent death or great bodily harm to himself. So did Joseph Rosenbaum pose an imminent threat of death or great bodily harm to the defendant? No way. Did Anthony Huber pose an imminent threat of death or great bodily harm to the defendant? Absolutely not. Did Jump Kick Man or Gage Grosskreutz? No. None of these people posed an imminent threat to the defendant's life or to cause great bodily harm. The standard, when you make this decision, is what a person of ordinary intelligence and prudence would have believed in the defendant's position under the circumstances that existed at the time of the alleged offense. The reasonableness of the defendant's beliefs must be determined from the standpoint of the defendant at the time of the defendant's acts and not from the viewpoint of the jury now. So put yourself in the defendant's position. Would you have done the same thing? Would a reasonable person have done the same thing? Would you have engaged in the reckless conduct that led to this course of events? Would you have gone out after curfew with an AR-15 looking for trouble? Would you have aimed at other people? Would you have tried to use the gun to protect an empty car lot? No reasonable person would have done these things. The court has also instructed you on provocation. You cannot hide behind self-defense if you provoked the incident. If you created the danger, you forfeit the right to self-defense. By bringing that gun, aiming it at people, threatening people's lives, the defendant provoked everything. And if he does that, he has to exhaust all reasonable means to avoid a confrontation. All reasonable means. So if Joseph Rosenbaum's running at him, Joseph Rosenbaum is no threat to his life. And not only is the defendant expected to run, he's expected to yell, push, shove that rag doll around, run back for help, call 911, call for help, do all sorts of other things besides just turn and fire 4 shots as Joseph Rosenbaum falls helpless to the ground. Ladies and gentlemen, there is no doubt in this case that the defendant committed these crimes. He committed a first-degree reckless homicide against Joseph Rosenbaum. He put Richie McGinnis's life in jeopardy. He put Jump Kick Man's life in jeopardy. He intended to kill Anthony Huber, and he attempted to kill Gage Grosskreutz. All of those elements are true. The question is whether or not you believe that his actions were legally justified. And I submit to you that no reasonable person would have done what the defendant did. And that makes your decision easy. He is guilty of all counts. Thank you.
Thank you, Mr. Mayor. Let's take a break and about 2:25 hopefully. And please don't talk about the case. Read, watch, or listen to any kind of the trial. Said that, I wondered if I'd have given it a print command, you know. About 2:25 on that clock.
I clocked the closing hour 45 minutes. Is that what you have?
You know, you could have gotten away with murder because I wasn't timing it. After having, you were. How long did he talk?
He talked 2 hours and 8 minutes.
What?
No. I can give the exact starting times.
What's that?
I said I can give the exact starting times.
Well, why don't we call one of the networks and they can tell us because.
Detective Howard was lying.
What?
Detective Howard was lying.
So, well, let's get everybody under oath and work it out, and if necessary, we'll have a hearing on it. That's That's all that came through?
I think we agree for the most part on the second portion of the argument. It would have been from around an hour and 13 minutes. Detective Howard and I both timed the first part, and we have it, well, Attorney Richards has it as 37 minutes. I have it as 32. So I don't think it's 2 hour, even with his timestamps, it's not 2 hours and 8 minutes.
Well, look, I actually wouldn't have strictly enforced it. I was going to make my usual statement, but I won't because someone will accuse me of being biased against my own religion. But I usually have been quite permissive about this. I set very strict rules, and then I'm somewhat indulgent. So I probably won't call anybody about it. But so you can both talk for 8 hours.
I just want
to. Okay. Yeah, you got it.
May it please the court, ladies and gentlemen of the jury, good afternoon. Showing you a snippet of State's Exhibit 18, which Mr. Binger just spent 3 or 4 minutes showing that Mr. Rosenbaum wasn't around. And my client couldn't know that he wraps his head in orange. Chain, bag, orange. Ladies and gentlemen, we've had this video almost as long as they've had this video. But Mr. Binger will use this video to lie to your faces and tell you that Kyle Rittenhouse was taking advantage of the situation.
I object, Your Honor.
It's in the picture.
It's argument.
Ladies and gentlemen, this case is not a game. It is my client's life. We don't play fast and loose with the facts, pretending that Mr. Rosenbaum was Citizen A #1 guy. He was a bad man. He was there. He was causing trouble. He was a rioter. And my client had to deal with him that night alone. When I say that the truth matters and this is not a game, what do I mean by that? Mr. Binger is the one who put on the Kandiri brothers. The reason he put them on, in spite of what he might say today, is because he wanted you, now 18, soon to be 12 people, to say, gosh, that kid just went to that place and just protected it. He wasn't asked. He was asked. Mr. Kandiri's asked Nick, Nick got a group of people to go down there. The people from West Bend came. Provocation, another thing. Think back on November 2nd when this case started. Did you hear one word out of Mr. Binger's mouth about provocation? You didn't, because it was never said. But when his case explodes in his face, now he comes out with provocation. That was opening. And most importantly, in opening, quoting from Mr. Binger's first paragraph of his opening statement on November 2nd, 2021. This occurred after the defendant chased down Mr. Rosenbaum and confronted him while yielding an AR-14. Ladies and gentlemen, you've seen the videos. Mr. Rosenbaum sees, and I'll show you the video in my closing argument. You'll see Mr. Rosenbaum take off when he sees my client coming along with the Zeminskis to set up the ambush of my client. Provocation? I don't think so. The things that I've just pointed out to you, why is that a problem? Because 1, he's lying, 2, he's misrepresenting, or he wasn't prepared when he started this trial, and his closing argument has been a change to try and fit what has come out. Remember how when he was talking, there's no proof that the Rosenbaum and Zeminski knew each other? Maybe they did know each other that night, but they were together throughout the night. You see them together in pictures wreaking havoc in this city. And now we have the magic pixel camera that brings forth his provocation. I'm going to go through the charges and we'll talk about each one of them. Then I'll go through the witnesses and hopefully I'll bring it home in an honest and forthright fashion. Count 1, reckless homicide. My client shot Joseph Rosenbaum. Ladies and gentlemen, make no mistake, there was nothing reckless about my client's conduct that day in regards to Mr. Rosenbaum. Mr. Rosenbaum was coming at him. My client ran from him, retreated, which is not needed, continues to run. The plastic bag is thrown, the metallic plastic bag. Kyle doesn't know what it is at that time. It causes him to turn and look over his shoulder, pointing the gun in that direction. Mr. Rosenbaum, is he dissuaded by that? No, he is not. He continues running and advancing on my client. That whole time, the state doesn't say anything about Mr. Zeminski firing the shot, Mr. Zeminski having his gun out. Think of the circumstances as they existed at 11:50 on August 25th of 2020. He runs through that parking lot. He continues running on. He turns as he comes into that box canyon with the cars, the van, and I believe it's a Pepsi machine, and he turns because he has no place else to go. I'll show you the Zanin video later on. What's important about the Zanin video, you see that mob of people destroying the cars at Car Source 3, which Mr. Binger doesn't want my client to go and try to protect, even though he was asked by those individuals to protect that property. Nick Smith called him, hey, they're bashing up the cars and starting fires. Go down there. He goes down there. He has as much right to go there as anybody else in the city of Kenosha and be unmolested by the likes of Joseph Rosenbaum, Kelly, and Joshua Zeminski. And Mr. Binger says, oh, we'll get the Zeminskis later. Well, ladies and gentlemen, last time I checked, this is still the United States of America, and he has the burden of proof. If he wants you guys to believe that my client pointed a gun at him, call the Zeminskis. Put them on the witness stand, ask them questions, and let me or Mr. Sharafasi cross-examine him. That's how we do things in a court of law, but not in Mr. Binger's court. He says, I'm blaming the victim. As a defense lawyer, I might get accused of that more than some other people. Ladies and gentlemen, Mr. Rosenbaum was shot because he was chasing my client and going to kill him, take his gun, and carry out the threats he made. And Mr. Binger wants to make a big hullabaloo about the shot in the back. Remember his opening statement. He shot him in the back. And that's why I'm sitting here in front of the jury like this. Did he shoot him here? Did he shoot him there? Because of the way the bullet went in and where the bullet ended up in the hip, you know full well that the individual, and I asked the doctor, is on a horizontal plane. What is that horizontal plane consistent of? Somebody leaping, lunging at my client. And we know how close Mr. Rosenbaum was to my client. The furthest he could have been when it started, the first shot, 4 feet with the stifling. We know that his hand was on the gun. Mr. Binger wants you to believe that that was just happenstance and accident. Come on, people. Physical evidence does not lie. Use your common sense and good judgment. He talks about Mr. Rosenbaum just somehow ending up down at the riots. Remember that? Mr. Rosenbaum, according to the testimony, walked from the bus center 4 miles out to Ms. Swartz's house, and then he couldn't stay there for some reason, and 4 miles all the way back. That's not just ending up. That's going someplace with a purpose, and throughout the night you saw his purpose. And there was more than one piece of testimony about Mr. Rosenbaum, whether it was a hospital or whether or not it was a jail. Remember that? And there was testimony regarding his medication. Ms. Swartz said we couldn't get medication because the Walgreens were all boarded up. She said, the hospital said, they gave him his medication. So whatever facility gave him his medication. Mr. Binger, the man with the burden of proof, why didn't he bring in a hospital or a jail to prove that Mr. Rosenbaum was properly medicated? He'd been off his medications, according to Ms. Swart, for 7 to 10 days. We know that he was acting like somebody who wasn't on their proper medication. He was not acting normal. Next. Richard McGinnis. Reckless. And here, Mr. McGinnis, I'd like to talk about, because the self-defense does not go to Mr. McGinnis, but if Kyle was privileged in exercising self-defense against Mr. Rosenbaum, it carries over to the endangering count of Mr. McGinnis. And Mr. McGinnis, specifically, if the defendant, and I'm reading directly from an instruction, page 9, second full paragraph, which you will be given, if the defendant was acting lawfully in self-defense, his conduct did not create an unreasonable risk to another. That is Mr. McGinnis. Ladies and gentlemen, when my client shot Joseph Rosenbaum, he feared for his life. He feared because of the prior threats, the prior statements, and the violent acts that had been witnessed by my client. Mr. McGinnis, as a witness, I think he helped us more than he hurt us. He talked about, and this was on cross for Mr. Binger, how do you know what Mr. Rosenbaum was thinking? He goes, I don't, but I know he yelled, fuck you, and then lunged at Kyle Rittenhouse. Why is he yelling the FU? One of two things. One, to intimidate, or two, he got into a situation over his head, thinking, as he said before chasing him, you won't do shit, MFer, to my client. Well, he was wrong. He states Kyle did not know that he was there, meaning Richard McGinnis. He's a citizen journalist who was running along with his hand in his phone in his hand up in the air in to get a story. My client is not responsible for endangering him when he runs into danger. Plus, the instruction says that if he was privileged as to Rosenbaum, he's privileged as to count 2, Mr. McGinnis. Count 3, jump kick man. The uncomplaining, unidentified witness in count 3. There will be some video later on when I'm going through some of that. You'll see, and I ask you to pay attention. The state has said he's not kicking him. He doesn't hit him. When you watch the video, and it'll be in slow motion, watch where his foot goes, watch what happens to Kyle's head. The force of him kicking him in the face spins his body 180 degrees around. And then it's on. Huber coming in from behind, hitting him in the neck with the skateboard. Ladies and gentlemen, what you see throughout event number 2, and this is the beginning of it, is individuals working in a mob. They don't know what happened at Car Source 3, event number 1. But somebody said, hey, he shot somebody. Doesn't know that he was being chased by a crazy person. But they're going to get their licks in on Kyle Rittenhouse, or, as they perceive him, somebody from the other side who has been putting out their fires, causing problems for them, stopping them from wreaking havoc in Kenosha like they did the night before. And ladies and gentlemen, the standard is likely to cause death or great bodily harm. Great bodily harm is defined as likely to cause serious bodily injury. A kick to the head is likely to cause a serious injury. Did my client suffer a debilitating injury as a result of that? No, but that's not the standard. Mr. Huber, he's a rioter, pushing a dumpster lit on fire, going to the barricades to pick up pepper balls, throw them back, pointing his middle finger at the police. He's assisting Rosenbaum at the gas station, hits Rittenhouse 2 times with the skateboard, and attempts to disarm him. You'll see it all in the slow motion video later on. And Kyle Rittenhouse is running away from Anthony Huber. The state wants to call my client an active shooter. And the reason they want to do that is because of the loaded connotations of that word. Everyone has heard of the theater killings, the school shootings, and things like that. Ask yourself, the definition of an active shooter is somebody with a plan to inflict multiple casualties, usually out of anger or animus towards a group. This case, what caused Kyle Rittenhouse to shoot somebody? Joseph Rosenbaum. He runs after shooting Joseph Rosenbaum for almost 2 blocks before scene number 2. Mr. Binger makes a big thing about Kyle Rittenhouse not staying around Car Source 3 after the shooting. Ladies and gentlemen, if Kyle Rittenhouse had stayed at Car Source 3, all that would have happened is it would have made the police have an easier job, because scene 1 and scene 2 would have been put in the same location. My client ran 2 blocks without shooting at anyone, pointing at anyone, doing anything to try and get away. He tells the individuals he's going to the police, and he's running in that direction when he stopped. He's hit in the head with a hand with a rock in it, knocking his hat off. Mr. Binger says, oh, he just knocked his hat off. I don't think that individual was trying to steal Mr. Rittenhouse's hat. He was trying to take his head off. Who comes in next? Anthony Huber, for the first time. Hits him. Opening statement, Mr. Binger, was he takes a swing at him. Now it's he blocked because we took the videotape and lightened it up. Huber strikes him in the head and arm the first time. Jump kick man comes in, kicks him in the face, spins his body 180 degrees, and Anthony Huber comes in for the second lick to the shoulder neck area, trying to take his head off. And when he does that, his other hand goes grabbing for the gun, his bare hand onto the gun and pulling it away from Kyle Rittenhouse. Mr. Binger wants Kyle to sit there and hope and pray to God his strap works, and Anthony Huber can't get the gun. We don't know that. We'll never know that as he's running away from him. A shot as the gun is being separated from his body, and you'll see the butt way far away when the shot is finally fired. Even Gage Groskwitz said he was concerned about the blows that Jump Kick Man and Anthony Huber were inflicting on Kyle's head. That's probably the only thing I agree with Mr. Groskwitz. Gage Groskwitz. The state must prove beyond a reasonable doubt that what Kyle did under those facts and circumstances was unreasonable, that he was not entitled to self-defense. Consider all the events that had occurred that evening. Him being attacked, kicked in the head, hit in the head with a skateboard, other individuals running up on him, and now Mr. Groskwitz runs up on him. And the first action of Mr. Groskwitz, and I'll go through the video later, is really he's running in, the hand is coming up, and the gunshot with Huber goes off. And the natural reaction is the flinch. He covers up. And then he pulls his hands up. And as he's standing with his hands up, look, he's not gripping the gun anymore in a pistol grip. Hands apart, hands up. And as he comes in to finish the job, the hand is on the gun going for Mr. Rittenhouse. And he says it's an involuntary movement. The shot comes before it gets directly to his head. But the motion is coming, the shot, and it continues on with that momentum. Enough momentum to go through the bullet and point directly at Kyle's head. Does Kyle fire again? No, he doesn't. Actions likely to cause death or great bodily harm. And he is coming in with a loaded Glock. And we asked Mr. Gage Groskwitz about it. He wouldn't even admit that there was one in the chamber. That's why we had to put on the officer to talk about the unfired shell casing. Lukowski talked about clearing the weapon and a live round coming out. Because Groskwitz won't say anything that puts him in a bad light. Groskwitz, the person who has 10 million reasons to lie. And we all know he did lie, because he never gave a new interview after giving his statement saying he dropped his gun going down the street. Ladies and gentlemen, those are the charges. Those are a synopsis of the charges. As I stated, the burden is on the state, and they must prove beyond a reasonable doubt that my client did not have the right to self-defense. Kyle, as he sits here, is presumed innocent of all charges. If there is any reasonable hypothesis to reconcile with Kyle's innocence, that is what you are to choose. remember when looking at the burden of proof, they have it. Think about some of the things, the shoddy investigation, the rush to judgment from the Kenosha District Attorney's Office, the Zeminskis not being called as witnesses. They have the burden of proof. We don't. They want it to be that Kyle was out there doing something improper. Kyle was a 17-year-old kid out there trying to help this community. He was asked to provide help in protecting property at the car sources. It started, and he did it. He did provide aid, and he was asking if anybody needed aid. Whether somebody chooses to accept that aid, that's on them. But Mr. Binger wants to poo-poo his sincere belief that he's helping people because he borrowed bandages from Dominic Black, and I think he might have borrowed something from Lukowski also. But in the picture, when the Kandiri poses with all the people who are going to protect his property, there's Kyle's big orange gator box. He's got his pack on, filled with things, and he's willing to do that. Ladies and gentlemen, Kyle was not an active shooter. That is a buzzword that the state wants to lash onto because it excuses the actions of that mob on the 25th of 2020. Whenever Kyle was there, he reacted to people attacking him. There's numerous times, and you'll see him on the video, he does not shoot. He runs 2 blocks from 63rd to 61st, scene 2, without firing his weapon. Individual hits him in the back of the head. He does not turn around to address that threat. Huber takes a swing at him with the skateboard like that. Kyle blocks, and the skateboard's knocked out of his hand. He doesn't turn around and shoot him. He keeps running and falls from the 2 hits. He's run that far, and yet somehow he just fell over on his own. As soon as he's on the ground, they're there attacking him. And you see the people the law of self-defense. You've seen it, you've heard it. Now I'm going to go through the witnesses. Oh. Dominic Black, first witness, charged by Mr. Binger for providing the gun to my client. 2 counts, looking at up to 6 years in prison. His case has been adjourned so that he can help the state. I don't think he helped the state that much. I think he was a pretty truthful witness, all in all. He told them about Kyle there to help people, that they had permission from the Kandiris, that he saw Kyle help the woman with the foot, help the person with the hand. Mr. Binger wants to just say, oh, that doesn't matter. If it wasn't Kyle, it would have been somebody else. The point is, he was there, and he did it. There was no pointing by Kyle of any laser sight. There was no ability for Kyle or him to point laser sights at anyone because their guns didn't have the type of optics that did that. He said Kyle was there to help. The only person helping was Kyle. And he can say what he wants about whether or not he let Kyle take the gun or not take the gun. He never told him not to. He went to the location with him. They bought straps at Jelensky's together. He's trying to cover his butt a little bit. The guns were there, and they took them. They took the guns, as he said, to deter people attacking them. He saw Kyle at the end, sweating, was in shock, and said that he shot someone, he had to do it. That is Dominic Black. Corey Washington saw the rioters breaking up concrete at the church parking lot. described Rosenbaum as erratic, stated the crowd was suspicious. I don't know what that means. One of the things that I thought was strange was the night before they were burning garbage trucks, but they only burnt the old ones. I think that tells you something about his point of view, that there's a certain amount of property damage that is justified and okay. Kenosha was using those garbage trucks that the rioters lit on fire, and nothing regarding property destruction was going to do anything to help Jacob Blake. We also learned that Kyle Rittenhouse smokes cigarettes and that he has an affinity for the Dinosaur Museum. Detective Howard, ladies and gentlemen, Detective Howard's testimony and Detective Antaramian's testimony is the stuff of what reasonable doubt is made of. Two detectives, both lead officers on this case. They've sat through every minute of this trial, and their opinions of the actions of Mr. Rosenbaum from testimony, videos, couldn't be more diametrically opposed. Detective Howard, on cross-examination, knew that the guy was hiding in the car and jumped out from behind the car and began chasing Kyle Rittenhouse. Oh boy, that's not good for the state's case. So there's the old chit-chat between Mr. Howard and Mr. Antaramian and the prosecutors after, and all of a sudden we've come up with the new theory. And you heard the new theory, that he raised the gun and that's what's on the video. Could I have the firearm, please? He told me he checked it.
He checked it?
He told me he checked it.
Okay. When?
Before lunch.
After lunch?
Before lunch.
Check it again.
Thank you. Think about when Kyle Rittenhouse is firing the gun, when he's seen holding the gun throughout the events of the 25th. He's shouldering the gun, and I'm not going to bring it all the way up to my shoulder, to the right shoulder, which would be a stance like this. The reason I objected in his closing argument is because that's not the way he was standing. If he's standing like this is right-handed, pointing the gun this way, up at the ready, his back would be to the drone footage. In the drone footage, you see the arm. It would be somebody having to hold the gun left-handed. This is a right-handed firearm. If this gun is brought up to his face and it is pulled back, the shell casing, hot, and the fire that ejects it is going to be going right into Kyle's face. The photograph I'll talk about later. You don't see the straps on his shirt. It didn't happen the way he said. It doesn't happen the way in the photograph. I'm going to need this again, but I'm going to set it down. Burden of proof, once again. The telephones, the searching of telephones with search warrants, the subpoenaing of records. I have no problem with that. It's good police work. But when you pick and choose and you make favorites, it's not. My client testified, and I'll say it this way, the detective testified that my client's phone was sent to the FBI. It was unsearchable because of the operating system. The FBI and the federal government had not cracked it yet. We found out about that. We had nothing to hide. Here here's the numbers, search the phone, as long as we're given a simultaneous copy. So we have what you have. We can have our experts look at it. They can have their experts look at it. So we know that there isn't anything added or deleted. We did that. We gave that to the state. If we had something to hide, they never would have gotten in that phone. They took the phone, they made a copy, they searched it. Lo and behold, nothing of an incriminating nature in it, nothing militia, white supremacist, any of that. Gage Groskowitz, different story. They had a valid search warrant for it. The only search warrant that these guys have never not executed when it's sitting right in front of them. Not just that, but Mr. Groskowitz could have consented to them going in the phone. If he has nothing to hide, why not? Why not let them look in the phone? And let's take common sense and judgment one step further. Police officers get search warrants. They execute the search warrant. Sometimes somebody feels as though their rights have been violated, and it gets litigated in a court of law. If it was illegal, the information in that search warrant never comes out in court. If it's legal, after a judge has said there were no rights violated, it comes in evidence. What was Mr. Groskowitz afraid of? Why wouldn't the state execute the search warrant, let Mr. Groskowitz and his attorney object, file a motion and say, you can't go in my phone? Let the judge decide, not the person who's prosecuting and protecting Mr. Groskowitz. Come on, people. Mr. Groskowitz has 10 million reasons for not wanting somebody to go in his phone. The timing with the detectives and some of their actions, I think, are very important. They get down to Antioch at about 3:30 in the morning of the 26th, less than 4 hours after this happens. By 6 o'clock, 6:30, give them the benefit of the doubt, Kyle Rittenhouse is under arrest for first-degree murder. There's not been any autopsy done. There haven't been any witness statements taken. They've got 2 or 3 videos. The bullets, I should say it this way, all of the bullets have not even been picked up from Car Source at this point. But they're willing to make a decision. And were they under pressure? I'm sure they were. They're afraid that there's going to be another night of looting, destruction in Kenosha because of this happening and the way the word got out. He traveled across state lines. He was here. He brought his AR with him. The AR was here. He was a white supremacist looking for trouble. Nothing. That's why, ladies and gentlemen, when we picked you guys as jurors, we asked you if you could decide based upon the evidence that happens in the courtroom. Not what you'd heard before, not all of the lies and untruths that have been put out in the media. I heard one guy say, my client discharged the gun 60 times. Ladies and gentlemen, what's happening in court is what you decide the truth on. He was charged on the 27th. Still, they didn't have the information, the autopsy's final, anything like that. Ladies and gentlemen, this has been a rush to judgment. Richie McGinnis, I talked about earlier, citizen journalists. Mr. Binger talked about him seeing guns. But remember the cross of Mr. McGinnis. Guns are not legal in Portland, Washington, or D.C. or New York. They're not allowed on the streets. You can be arrested. There are state laws. And ladies and gentlemen, the gun in this case is no longer an issue. whether or not it was a dangerous weapon as it applies to the charges is, but my client is no longer charged with minor in possession of a firearm. But he needs his AR-15 and the assault weapon and the fear that goes with that to try and bring home an unjust guilty verdict. Ryan Balch had never met Kyle Rittenhouse before the evening hours of the 25th, has never spoken to him or known him after. And yet the state wants you to believe he made up something about a threat to kill. Why? What's in it for him? The threat. If I get either of you alone, I will kill you. That is a threat with a statement and a promise. And lo and behold, the chance presented itself to Mr. Rosenbaum, and he attempted to execute it. And I don't for a minute believe that he would have done it if it was Mr. Balch, who's much bigger than my client, muscular, well-built, and much more assertive and forceful. Rosenbaum, like any, as he referred to him, I don't even know what he called him, a ragdoll, whatever, but the little guy who gets beat up likes to go after the next littlest guy. He saw Kyle alone, and that's what he chose to. Or he could have been mistaken and thinking it was the other person at the ultimate that he went after and had to be held back. They were dressed very similarly, baseball caps, mask, and the only difference was the difference between shorts and a long pants. I can't answer that. Mr. Rosenbaum at this point, I guess, can't either. But you see Mr. Rosenbaum right around the time in question at that location, menacing with his chain. I'm going to finally get this right. I skipped. That's Mr. Balch. I talked about him going on. Ms. Amber Rasmussen, she was the DNA expert. What I say to you is DNA is an incredibly useful tool, but DNA is only as useful as what you put into it. And if DNA shows anything, it shows that it's not proof positive in this case. We know in hearing from Dr. Kelly that he most probably touched the gun. It was a contact wound is the way he described it. And we know through the videos Huber touched the gun with his bare hand, and yet no DNA was found on that gun. So don't let your eyes deceive you. Don't let the physical evidence be discounted because of what she said. The end of that barrel was not swabbed. And we know he had to be at the end of the barrel, or it would have had the soot on all of the fingers. Jason Lukowski, thought was an interesting witness. He was the Marine who put the phrase, shout, shove, show, shoot. And I asked him about that, and I don't for a minute disbelieve that that's the Marines' rule. Is there any retreat in there? And he said no. He looked at me like I was stupid. The reason he looked like that was because they don't retreat. Yet Kyle Rittenhouse did retreat. He tried getting away from Mr. Rosenbaum. He described Joseph Rosenbaum as belligerent, with malintent, used the N-word, did the false step thing, did not see Kyle as aggressive. He was there for a shorter period of time than anyone else at CarSource. He also cleared Gage Grosquist's gun after the shooting and made it safe, took the shell out of it. And I ask you to think back to the direct examination of Mr. Lukowski by the state. When they asked him, what did Kyle say to you? His first statement was, I just shot somebody, I need help. That's what he testified to. And then Mr. Binger shows him the statement and gets him to say, well, I told the FBI that. Ladies and gentlemen, I don't know what he told the FBI. The FBI doesn't let him see that statement, doesn't let him read the statement and say, you've read this to me, it's true and a correct copy. They write down what they think they heard. I ask you to think about what he said. If he didn't shoot somebody, why does he need help? That makes no sense. He said it, he testified to it, that's what happened. The state confronted him and pushes him back to his original statement so he doesn't get in trouble. He put the tourniquet on Gage Grosskreutz. He testified that he had his AR-15 with him, providing medical services, first aid, just like Kyle Rittenhouse. And I find it so ironic that he was there. Gage Grosskreutz had said to them, go home, we have our own medics, you stooges. And who ultimately helps him with his tourniquet? Sarah Hughes, her testimony, she reminded Mr. Huber and his girlfriend they needed to be home by curfew. Obviously, not advice that was followed. Wish it had been. Carrie Ann Swart, I talked about. She talked about Joseph Rosenbaum being bipolar, being prescribed gabapentin. He had to leave her house that night after walking 4 miles, taking about an hour, and then walking another 4 miles back to downtown where the riots were going on, where he could involve himself fully. Her story contradicts Nathan DeBrune. I just got out when he said, I just got out of jail and I'm not afraid to go back. He'd been off his meds for the week prior. The videos of Joseph Rosenbaum show the state that he was in. No proof that he ever took his meds. Saul Kindiri, he was the first of the Kindiri brothers to testify. Car source. He's in the picture with all the people who protected his property. He's there, and he said he just liked the military garb. Why did he get a picture then with just one of them? How did he wrangle all these people up? Everybody in that picture said that they wanted him there. They gave him permission. Even Dominic Black concurred in that, the state's witness. But as I said earlier, they want these two guys to dirty Kyle up. He's just picking a spot to pick trouble and to be there and cause problems. He was asked to provide security. He did. They deny that they were going to pay any money, yet Nick Smith says they were. And going to pay money to Nick Smith. And ladies and gentlemen, do you get the feeling that they're a little afraid of being sued, as everybody else in this case is? I think so. And when they were up there, I don't remember them saying, oh, you can protect car source 2 or car doctor, but don't go to car 3. They had somebody arranged to protect car 3, car source 3, and the word came in that they had left. Dominic, Balch, Joanne Fielder, all of them say they had permission. Why would they lie about that? How does that protect them? They're not charged with anything. Who's the people who are lying here? Sal and Sam. Next, Police Officer Widener. He was the ET. He went and recovered some of the 2-3 rounds from car source. I believe he found 3 of them. The other 2 were found 3 days later. He photographed a mask. He didn't find the bag, and we do not concede that there was nothing in that bag. Not for a minute. They have the burden of proof. They have the burden to preserve a crime scene appropriately, get the evidence, and show it to you. Ryan Balch said he smelled ammonia and bleach. They didn't find the fire extinguisher. We know that the fire extinguisher was there. It's in the videos. But that doesn't fit in the state's narrative of Kyle actually going there to put out a fire, which had been started earlier in the Duramax. Officer Van Wee recovered the last 2 shell casings. Strike that. I love technology. Officer Van Wee. Officer Moretti. He was the driver of the squad car that Kyle tried to surrender himself to. He said it was a war zone. It was a war zone those 3 nights. He described it as the city on fire. The police felt as though they were completely surrounded, described the constant gunfire that evening. Mr. Binger wants to slough it off as fireworks this. It really wasn't that bad that night. Ladies and gentlemen, it was hell in this area downtown. There were violent people causing trouble. And the state wants us to believe it was okay. The police pushed them back. Now they could leave. Car Source was safe. And I can't remember specifically what witness it was, but it stuck out in my mind. The witness said the police pushed him back, let him back, pushed him back, let him back. And a lot of the burning happened late at night, that witness said. Gage Grosskreutz, 10 million reasons to change his statement. His attorney is sitting in the courtroom, has been sitting in the courtroom when he testified. If he's just your average complaining witness, why get a lawyer? What do you got to hide? He didn't have a valid concealed carry permit. He wasn't charged. He lies to the police about being armed that night. He said he dropped his gun going down the street. Ladies and gentlemen, that's what's called obstructing. Most people, when you lie to the cops, especially in a murder investigation, you get in a little bit of trouble. I've represented some of those people. Not Mr. Grosskreutz, because he's their star witness. Bought, paid for, and protected. You don't want us to search your phone? Oh, we're going to invoke the never heard before Marcy's Law exception to the search warrant, even though they had a signed search warrant by a judge of Kenosha County. He was also an armed medic. Wants you to believe that he didn't have one in the chamber and he would never shoot somebody. But before he said that, he said key, wallet, phone, gun. He never leaves the home without them. Ladies and gentlemen, I don't carry a concealed weapon. And I don't think I could shoot somebody. But when people carry guns, that's what they're for in the city. This isn't the Wild Wild West. He had his gun. Kyle Rittenhouse had run by him. You'll see the picture. Was by him, gone. Did he go to give medical help? He didn't know that Mr. Rosenbaum was being tended to. No, he decided to run in and advance on the fray. He, affiliated with the American People's Revolution here in Wisconsin. And I might have that one word wrong, but he did it. And who ultimately put the tourniquet and fixed it on his arm? But Mr. Lukowski, a member of somebody he refers to as the militia and the Stooges. 2 different encounters between Gage Grosskreutz and my client. The first one, he does not show or give any indication of a weapon. My client does not point a weapon at him, does not shoot at him, does not swipe the weapon towards him. He states he's going to the police. That is uncontradicted. Why doesn't Mr. Grosskreutz let him be and go give aid and comfort to his fellow rioter? But instead, he joins the mob, chasing Kyle, arms himself, and runs in the fifth or sixth person into the melee in scene 2. And when his friend was called, his friend said in his Facebook post, his only regret was not emptying the clip into the kid. So we know what his intent was. We know what he wanted to do. Kyle shot first as he was coming in. And Mr. Binger talks about, oh, he was going to grab the gun. Ladies and gentlemen, left hand, phone. How's he going to grab a gun with a hand filled with a phone? Right hand, gun. He goes back, loads up, and is advancing. That's when Kyle shoots him. He didn't shoot him when he put his hands up, and if that was it, no intent to harm him, all he does, like everybody else, is back up, and nobody else gets shot. But Mr. Groskowitz decides he's going to shoot my client. Unfortunately, my client shot him first. If he had retreated, it's over. And when he's got his hand up like this, as I said earlier, the hands are up. It's not gripping the gun, it's loose. But when he goes in like this, the pistol grip is tight. Heather Williams, Crime Lab, she testified that the gun works. I have no dispute regarding that. Detective Krieger, he was in the passenger seat of Moretti's car, pepper sprayed, did not get his ID, didn't ask him about the gun, just told him to go home. Kristen Harris, Rundown Live, stated the video, we showed the video to start this, clearly depicting Mr. Rosenbaum standing there at Car Source 2 shortly after the dumpster, standing there with his chain, the shirt tied up over his head. But Mr. Binger says it's impossible for him to have threatened my client. That's garbage, just like his case. And Mr. Binger makes so much out of him one time saying, stay on your property. My client has as much right to go anywhere in downtown Kenosha as anyone else. Just as the rioters did, and as he walks out to see if anybody wants medical help, he's not doing anything wrong. He's not doing anything to provoke anybody. Detective Antaramian, the juxtaposition of him and Howard, as I said, he is the one who talks about what he sees in the video, totally different. As you see, why did Mr. Rosenbaum go behind that car, 2 cars over from the Zeminskis? What was he doing over there? Why was he doing over there? And why does he come out as soon as Kyle comes down the road? Because they were going to ambush him. They had set it up, and I'll show you the video. James Armstrong. The only thing I can say about James Armstrong is, okay, that's interesting. But what I'd like to say about his photographs, his knowledge of what he did, and some of the statements that the state has made regarding it is, what he did for those 20 hours is hocus pocus, and he makes an exhibit that is out of focus. And that's what the state is relying. The picture does not make sense. As I showed earlier, it has Kyle shouldering the gun in the left shoulder. If he has it in the left shoulder, his back would be to the drone. The drone is moving around, and that changes the focal point. He's right-handed. That's where it goes. You'd see the crosses across his chest. But no, they need him to have somehow pointed a gun at the Zeminskis. I don't for a minute concede he did, But we know that Mr. Zeminski has been armed all evening. How would pointing a gun at Mr. Zeminski provoke Joseph Rosenbaum, who, according to the state, earlier in the case, they didn't even know each other? But I think they had to run away from that because there's so many pictures of them together. Mr. Armstrong's photograph, testimony, it took 3 days and 20 hours worth of work to come up with that picture. It went from color to black and white, and he admitted he never compared it to the original photograph. Still shot. Didn't take into consideration the fact that the drone was moving. The word peer-reviewed, state has said. Peer-reviewed is an independent verification of the events, the exhibit. So there was no testimony to this because it didn't happen, that Mr. Armstrong's coworker did 20 hours on the same photograph and came up with the same result. It didn't happen. When you see, and I'll show it to you later, when you see in the video the mirror and the shininess of the mirror, that's what that is. And by going around, spending 20 hours and bringing things up, it doesn't account for Kyle's arm, it doesn't account for the heat signature of the gun, none of it. Dr. Kelly. Personally, my favorite witness, because physical evidence doesn't lie. The soot, extremely close, if not touching. The location of the soot, I had him circle it on the exhibit. On redirect, after I had him do the demonstration and draw on the photograph, the state tried to get him to back up his opinion, back it off. He wouldn't, because the physical evidence doesn't lie. It's, as they say in the business, an inconvenient truth. They can't change it. It is what it is. That's the demonstration that happened in front of you, the gun and the hand. And if the individual's coming straight at it, the barrel of the gun, it would go through the hand like this. But we know that it was coming from right here, going down, and came out with a very clean exit wound. No soot here at all. So we know that the gun can't be here. We know there's just a little bit of soot on what's commonly referred to as the ring finger right here, and the bulk of it goes this way because it was over the gun, touching the gun. And Mr. Bigger says he was swiping at the gun. Ladies and gentlemen, he didn't need to chase him, didn't need to keep chasing him, didn't need to lunge at him, didn't need to swipe at the gun, i.e. grab the gun. And the shot to the back, as I said, 4 shots in 3/4 of a second. He's backing up, trying to stay away from him, shooting, and he shoots until the threat is immobilized. Ladies and gentlemen, other people in this community have shot somebody 7 times, and it's been found to be okay. And my client did it 4 times in 3/4 of a second to protect his life from Mr. Rosenbaum. I'm sorry, but that's what happened. And this is the prosecutor who said he shot him in the back. He shot him in the back on a horizontal plane consistent with lunging. The shot goes in here and ended up in his lower hip across the back. If he's on the ground or down and shot, the bullet goes into the back and ends up in the stomach or on the other side. It cleared back here, ended up in the lower hip. That's because he was on a horizontal plane when Kyle shot him. He had stippling to the stomach from the first. The pants stopped it from lower, but it was still on the upper. The furthest he was away when the first shot was fired was 4 feet and closing. 4 feet. I think it was Mr. Kraus and I who had to fight about how far 4 feet is. It's not that far. It's not that far at all. Brought a tape measure so I could measure a gun barrel for you today, but that's no longer an issue. So I'll show you what 4 feet is. No doubts. From the edge of the jury box to my foot right here, 4 feet. Lunge, grabbing the gun. Think how close that is. Think how fast that distance is closed. What was Joseph Rosenbaum doing? Was he running after my client to give him a key to the city of Kenosha? Was he running after my client to say, hey, thanks for providing security? Use your common sense and your judgment. Look at Mr. Rosenbaum's behavior throughout the night. As I showed you, these are the pictures. One last. I'll get you the pointer. Exhibit 105, Dr. Kelly. So, right here. Here's entry. The exit's right over here. Goes across, clean, came out right there. This right here, nothing. Nothing on the back part of the hand, no soot. We know what was over the barrel. Remember Mr. Kraus asking the doctor, well, what about that big puff of smoke? That wouldn't have an effect. Soot only goes so far. That was Dr. Kelly's testimony. He doesn't have a dog in the fight. He looks at the bodies, says what they are, makes a determination, and looks at the evidence. We had an expert, didn't call him because Dr. Kelly told the truth. Couldn't agree more. Ladies and gentlemen, facts and truth matter. In most trials, the case would have ended with Dr. Kelly. But we wanted to bring you our side of the story. We had nothing to hide. We were going to put on a defense. I heard Mr. Binger say red herring. The red herrings in this case are by the state, talking about super bullets, this metal jacket. I've been involved in homicide cases. One time it's a metal jacket. The next time the problem is the person had hollow points. Hollow points are designed to kill. Full metal jackets are to go through people. Ladies and gentlemen, bullets are bullets. Hate to tell you, at close range and close contact, they wreak havoc on a body and they kill people. No dispute. Wants to keep pointing at the militia, the militia, the militia. He knows Kyle's not a member of the militia. He has no evidence that he is. They went to the websites. They went to TikTok. They went all of that. All they can do is put up a little thing of a 17-year-old kid from his TikTok trying to be famous. Kyle shot Joseph Rosenbaum to stop a threat to his person. And I'm glad he shot him, because if Joseph Rosenbaum had got that gun, I don't for a minute believe he wouldn't have used it against somebody else. He was irrational and crazy. Talked about active shooter, the power of those words. My client didn't shoot at anyone until he was chased and cornered. Nick Smith. Got a phone call from Sam, asked on the second night of riding to go down there. They used the power washer and buckets to try and put out cars. He did that out of the goodness of his heart. Sam asked him to come and protect the next night and be paid, and he agreed to do it. He asked some of his friends to come with to help. Kyle, Dominic Black, talked about another father and a son, and then the people from West Bend showed up. He said that when they first saw Sam on the 25th, Sam gave him a hug and thanked him for protecting his property. He was on the roof when it was chemical bomb. He knew that Sam was grateful for their presence, but he also knew that people on the ground needed weapons. He heard Kyle when Kyle came back saying, "I had to shoot." Body armor. I don't know why the Grays Lake Cadet Program gives people body armor. Don't know. My client had it. And if he wanted to be an active shooter, as Mr. Binger wants to portray him, why would he give up his body armor? Nick Smith wanted body armor. He goes, "Here, Nick, use mine. I'm going to be doing medical." Helping other people. You see him do it throughout. He gave Nick his body armor. Why would somebody give up their body armor if they're going to go out looking for trouble, seeking confrontation? Doesn't make sense. Joanne Fielder, she described Joseph Rosenbaum wearing a red shirt with a green earring. She described yellow pants, well, I'll get to later. She stated Joseph Rosenbaum yelled he was going to kill us MFers and cut their hearts out. JR's arm goes up, and within seconds, they're tearing up from a gas bomb. She couldn't say for sure that she saw him throw it, but obviously that's the circumstantial evidence in her belief. She never saw Kyle act inappropriately with anybody, point a weapon at anybody. The size of the weapon might change, but it doesn't change what it can do. Presence speaks volume. It's a deterrent, and they've been pelted all night long with rocks. She was aware that they had consent to be where they are. Nathan DeBruyne. Interesting witness. He was out there taking photographs on the nights in question, more importantly the 25th. He filmed the destruction of this community, uptown, downtown, and the ATF and the FBI found out about his videos, his still photography, which I think was incredible. They wanted it, and what did he do? Didn't ask for money, he gave it to them. He sat down with the detective and gave a full interview, showed him the photographs, talked about Mr. Rosenbaum and all the problems he was causing that night, the things he was doing. And that's within less than a month after this. He'd never met Kyle Rittenhouse, didn't know Kyle Rittenhouse, but he had a feeling about what happened that night. And he said if there was trouble, Mr. Rosenbaum was there. I don't think any truer words have ever been repeated. Did he have a lawyer when he met with Detective Howard? No, he didn't. When did he get a lawyer? Remember? After he met with Mr. Kraus and Mr. Binger. Mr. Binger, the person who's made it his personal goal of putting my client's head on his wall. Ladies and gentlemen, that's what it did. And it means he's been cutting corners. And Nathan DeBruyne said, after meeting with Mr. Binger, I was very uncomfortable. He tried to put words in my mouth. And he had to go and hire a lawyer to protect him. First it was show him the videos and then ask him the questions, trying to put words in his mouth. He didn't want that to happen. He wanted to be able to tell his story of what he knew, what he did. He talked about Zeminski, the photographs of all the conduct that Zeminski had done that night, and I'll show you some of them. The photos have a timestamp on them, and He related to Detective Howard in September of 2020 about Joseph Rosenbaum yelling, "I just got out of jail and I'm not afraid to go back." Those are his words that he heard Mr. Rosenbaum. It was not objected to by the state, and there has been no proof that he wasn't in a jail. They want you to believe he was in a hospital. There's no medical records he was in a hospital. There's no medical records he was properly medicated. And I submit to you that in this case, the way he was behaving, I don't think he was properly medicated. There's pictures of him with the trailer fires, the chains, starting numerous dumpster fires. I submit that he was with the Zeminskis on many of the occasions, and he was emboldened by Mr. Zeminski because Mr. Zeminski was always brandishing his firearm. We saw Joseph Rosenbaum taking the chains. He chose to come down and riot, and that's what he did. Nathan DeBrune chronicled that. Why did he chronicle it? Because it's not very interesting if you take a picture of a protester who's just standing there, but Mr. Rosenbaum was involved in all these different things, and I'll show you those pictures. Lucas Zanin, Kenosha County resident. Every now and again he goes down to Texas in the winter. Testified, born and raised. He stated he had empathy for the small businesses of Kenosha, did not want them looted, did not want them burned. Is that somehow to be called into question? Does any of us want those fires started and to come and burn? I don't think so. He authenticated the video that was taken from his car as accurate, showing the south side of car source 3. And you watch that video and you see people destroying someone else's property. During the video, you look at the one wall, there's nothing there. You see somebody spray painting on it, and they've written the word loot on it. You see another individual going in the hood of the car, trying to do something. It's not his car. He's not some roadside mechanic. They're destroying property. Ladies and gentlemen, Mr. Binger and I will go round and round about it until the cows come home. They were rioters. They weren't demonstrators. Were the demonstrators down by the courthouse earlier in the night? Yes, there were people doing a legitimate demonstration. These people were rioting. And you see in his tape, they're hitting the cars with pipes. You hear the glass breaking. You see the people jumping on it. And the important part of it, and I'll show it to you, is you hear the first bang, which is Mr. Zeminski's shot. 2 seconds later, you hear the next shot, and then you see the exodus of all the people taking off from that. That's why Kyle couldn't run and continue to run from Mr. Rosenbaum, which he was under no legal duty to do whatsoever. Jacob Marshall referred to himself as Gage Groskitz's best friend. We brought Mr. Groskitz's best friend in as a witness because he had posted something on Facebook immediately after this. He testified he couldn't find Gage Groskitz because he was under an anonymous name at the hospital. Nobody knew who Gage Groskitz was, who Jacob Marshall was. But he takes it upon himself to post a Facebook message talking about how, could I have the next slide, please? I just talked to Gage. To his only regret was not killing the kid and hesitating to pull the gun before emptying the entire mag out. Coward. Here's the picture of them hugging each other at the hospital when this is posted. Ladies and gentlemen, why does somebody post something like that? Because that's what his friend told him. And he wanted to get Gage Groskwitz's word out. He didn't repost and say, I lied. He took it down to try and hide it. But unfortunately, the internet has a memory. Next witness was Kyle Rittenhouse. I'm done with the Kandari brothers. We did recall them, but I talked about that. Kyle Rittenhouse did not have to take the witness stand to tell his story. It was told through video. He wanted you as the jurors to hear his personal experience of the night of the 25th. He knew Mr. Binger would cross-examine him for hours, and he was willing to get up on that witness stand, take the oath, and tell his story the best way he could. And he did. Could Mr. Binger pick on him and find little things about it? A little bit. Did he damage his credibility? I don't think so. Getting to Mr. Yellow Pants, which he's been talked about. Mr. Binger talks about, he says with sarcasm. Ladies and gentlemen, you've seen the video. But remember that when Yellow Pants said to Kyle, he goes, you held your gun like this. That's low ready. That's not like this. It's down. He never pointed his gun at him. Did he have a gun? Yes. Did he tell him to get off a car? Yeah. But when he said it to Kyle, Kyle said, I did, and walked away, not wanting confrontation. And remember Richie McGinnis's testimony about that. There was the individual with the slingshot, there was the individual with 2 rocks in his hand, and the other individual with the gun. And when Mr. McGinnis walked up to him, he immediately had to put his hand down because they were the one advanced on him, and he bought him off with a White Claw. My client, when this happened, was 17 years old. His actions are to be judged as a 17-year-old, not by Mr. Binger's standards, but by that of a 17-year-old. And Mr. McGinnis said he didn't appreciate the way people looked at him. And maybe he didn't. And I think the best evidence of that is when Mr. Rosenbaum begins chasing him, you hear on the tape he yells, friendly, 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 3 times. He thinks that if he just says the magic words, they'll stop. They don't. They could have, Mr. Rosenbaum could have looked at it and said, hey, you're not trying to harm anybody. I'll leave you alone. Is that what happened? No. He said, you ain't going to do shit, mother effer, and began to continue to chase him. Mr. Rosenbaum made a fatal mistake. That day, chasing Kyle Rittenhouse into the corner, he ran as far as he could, and he shot 4 times in 3/4 of a second. Mr. Binger makes so much of Kyle's residence. Antioch, Illinois. I think most people here know where it is. It's not a foreign country. Antioch, Illinois, right across the border. He worked in Kenosha. His dad lived in Kenosha. His grandmother lived in Kenosha. He worked in Pleasant Prairie. His best friend, Dominic Black, lived in downtown Kenosha. They want you to believe that there's some sinister thing about that. Ladies and gentlemen, we live in a very mobile world. I'm from the foreign country of Racine, Wisconsin, 13 miles away, a little bit further. I'm on the north side. Ladies and gentlemen, when Kenosha burned, people who like Kenosha, they hurt. I remember 34 years ago walking into this courtroom, first time I ever appeared as a lawyer, back in that conference room. And when I saw what happened in Kenosha, it bothered me. Those 3 days. People can protest, but people can't indiscriminately burn property for no reason of innocent people. How does that further anyone's cause? Kyle feels for this community. He worked as a lifeguard. When he came down here, are we to believe that he's working to clean up graffiti, not getting paid because he's here to look for trouble? Is this all some master plan? That's ridiculous. He came down here trying to help, to see the damage, and that's what he did. Next. Dr. John Black, his testimony about the slides, making times, and I'll go over some of those. But specifically, as I argued earlier, the zero shot from, I should say it this way, friendly 3 times to the first shot, 10 point some seconds. There's a change in elevation in the video as he's lunging forward. The shot rings out after that. The zero shot, which is shot 1, then 2 2600ths, the next one 24, 23, for a total of .739. He gets up, he comes around the car because all the individuals had left. After hearing the shots, goes to check. And to believe that he could stay there is preposterous. All I said would have happened, scene 2 would have been moved to scene 1. You heard the one individual yell, "Get the F out of here." The Zeminskis are screaming, "He just shot him, he just shot him, get him, cranium." That's all happening. Mr. Zeminski's walking around with his gun over his head, pointing at Kyle, and I'll show you that in a little bit. In the exhibits that Dr. Black showed the jury, no color was added, no color was subtracted. The videos didn't go from color to black and white. There was no structural problems. He demonstrated his technique regarding changing brightness and contrast right in front of you. And the one video went from a dark mess of nothing, moved the 2 lines. I don't know how to do it, but he did right in front of you, hit it, and all of a sudden it's light and you can see it. The whole event that evening took 2 minutes and 55 seconds from the 3 times friendly to the time he surrendered or attempted to surrender at law enforcement. Officer Brittany Bray, let me go through the back up to the first one. Total time, 2 minutes, 55 seconds, according to Dr. Black. Next, friendly, the 4 shots, 10.8 seconds. Those are the shot times. Remember the sound he put and synced up with the video? That was the audio graph, the green thing he showed you. You can see when the shot is fired, he matches it up, times them out by the frames per second. You come up with those numbers. And that's because when you show something in slow motion, it looks like somebody can really have the time to think, process, and do all that. You have to remember how fast all this was happening in event number 1. He's running, the bag is thrown, he turns, addresses, keeps running, and makes a decision, a life and death decision, that he has to turn around and address the threat of Mr. Rosenbaum. At that point, Kyle is stopped. Mr. Rosenbaum, like those other people in event number 2, could have put up his hands and just backed up, made a bad decision, shouldn't have done it. No, he goes diving for him, yells the FU, and is going for his gun. Next. Event 2, I have it beginning when he's hitting the head with the rock and ending with the 4th shot, taking 14.9 seconds. Next, police officer Brittany Bray measured the gun, the pullback, the slide, 4 inches, brought the ruler out, because you never see in event number 2 Kyle pull back the 4 inches, slow motion or otherwise. There were no unfired bullets found at the scene for the AR. There was the unfired bullet by the clip and the Glock that had been cleared from Jason Lakowski. Drew Hernandez Mr. Binger, for some reason, didn't like Drew Hernandez. You could hear it in his questioning. Ladies and gentlemen, Drew Hernandez had a point of view. There's no doubt about it. But what was that point of view? He's a citizen journalist, and he's covering the riots. And he didn't think that the mass media was covering the riots correctly. They were just calling everybody demonstrators and not covering the devastation and the destruction that was being done. That's his point of view. It's kind of my point of view, too. But does that mean that his video's lying? Does that mean when he says, I saw him lunge, that he's lying? He doesn't have a dog in this fight. He tried to get all of his video to the state. The Dropbox wasn't big enough. He sees that the case is going to trial. He reaches out, gets a lawyer, and provides it simultaneously to both of us, and we end up playing it. He describes the Zeminskis, Joseph Rosenbaum starting fires in the dumpster, the yelling. He sees Kyle, the yelling of the word, the N-word. He sees Kyle walking around yelling medical, medical, right up until the last time when event number 1 starts. He was standing right at the corner, had a clear view to the first incident. He described him as charging from behind. He saw Joseph Rosenbaum throw the bag. He described hearing a shot from behind Kyle, which we all know is the Zeminski shot, the man who's never been brought before you people. And he saw Joseph Rosenbaum lunge. Ladies and gentlemen, you've sat through almost 10 days of testimony. You've heard the openings, most of the closings, and I have yet to hear Mr. Binger explain why Joseph Rosenbaum had the right to chase my client. To me, if I didn't know better, I would think he's a whiny defense lawyer. Everybody's out to get me. Everybody's lying. I'm the one who's bringing forth the truth. Ladies and gentlemen, the videos show the truth. The videos show the actions of Joseph Rosenbaum. Balch is lying. Fiedler's lying. Lukowski's lying. Richie is lying. Dale DeBrune, he's really lying because he's imputing my character. Nathan DeBrune, excuse me. Hernandez, he's lying because he's a right-wing journalist. All 6 of them are lying. And then, I forgot, Detective Howard, he's lying too because he could see through the videos. He could see that Rosenbaum came out from hiding behind the car after my client passed the Duramax. Rush to judgment, as I said earlier, you bet. Highly charged atmosphere here in Kenosha. Make no mistake, you live here, you know. They had to do something. They had to charge the white supremacist, who isn't a white supremacist. They've never reassessed their case. They've never looked at it. They've never said, oh, Dr. Kelly, let's talk about this wound on the hand. What? That means he was touching the barrel? Or his hand was over the barrel when it was fired? Well, that means he was pretty close. No, we're not going to reassess. We're going to march forward. We're going to throw it into the hands of 12 people from the city and let them do our work. Ladies and gentlemen, this is a political case. We can take politics out of it as in Democrat and Republican, but the district attorney's office is marching forward with this case because they need somebody to be responsible. They need somebody to put and say, we did it. He's the person who brought terror to Kenosha. Kyle Rittenhouse is not that individual. The rioters, the demonstrators who turned into rioters, those are the individuals who bring us forth. And I ask you to remember, and I'll show you the videos for the last time from me, the anger in the mob that was going on that night. They were not going to be dissuaded from doing things. They were pushing, firing dumpsters, destroying property, and that was So you're saying Mr. Rittenhouse put out a fire? Yes, it was a small fire. Last time I checked, small fires turn into big fires. So, kind of stupid. James Armstrong, hocus pocus, out of focus. I've talked about him. He spent 20 hours reworking a frame in a video and having my client somehow miraculously go from a right-handed shooter to a left-handed shooter. The mirror on the truck is the arm. Their whole case relies on that one photograph that he spent 20 hours. That's how they're going to prove provocation, a word you never heard in the opening statement. It was my client chased him down and shot him in the back. Oops, can't prove that. This is the day before, car source burning, car source 1 burning the ground. What's in the foreground? The trailer should be the subject. Pictures later on. There's Kyle earlier in the day on the 25th, setting up his alibi, setting up his I'm a good person story, because he thinks he's going to go out and kill 3 people that night. Ladies and gentlemen, that is garbage. How would he know he's going to be photographed? And what does that do? It just shows he's interested in his community, trying to do good. Picture, Mr. Kandiri at Car Source 3. The state doesn't want Kyle to go to Car Source 3. According to the state, he has to stay at Car Source 2, 59th and Sheridan. Yet, Nick Smith called and asked him to go there because whoever was going to protect that property had left.
On objection, Your Honor, the record does not indicate that Nick Smith made that phone call.
It's argument, folks, you heard the evidence and use your collective recollections to determine what the truth of it is and discount anything that is not supported in the evidence.
Testimony was he received a phone call saying they were destroying cars at Car Source 3, and he went down there. First, Kyle asked for a fire extinguisher, asked the other individual to go down there with him. He said, didn't give an answer, and Kyle took off going down there to try and help protect that property. This is that night, the tear gas, the fires. Here is Mr. Rosenbaum pushing one of many dumpsters, dumpster fires. Right there, that's one. Another one. Stop. Bats, guns, Mr. Rosenbaum pushing it in. Either the gas station or Drew Hernandez said there were police vehicles right down here. And they're trying to push it to him. I apologize. They're trying to push the dumpster down to the line of police or to the gas station. It's put out, and the reaction from Mr. Rosenbaum of dumpster number 2. You hear the voice? Why you do that? Get over this. There's Mr. Rosenbaum arguing. Mr. Zeminski, the smiling puppeteer, standing behind him. Yeah, they didn't know each other. Maybe they didn't, but they sure spent a lot of time together that night. Mr. Zeminski with the yellow circle, holding his firearm, yellow pants, Kelly Zeminski with a flashlight in her hand. Last time I checked, there wasn't any lighting problems. The flashlight is a weapon to bash heads if you have to. Many people with AR-15s, not one person with an AR-15. That's the difference between this, the Ultimate Gas Station, fracas, And what happened down at Car Source 3? Kyle Rittenhouse was alone. He had been taken away from the herd, and Mr. Rosenbaum and Mr. Zeminski were going to get him. Movement. Mr. Rosenbaum and his bag. He's not dissuaded by the people. He's going right at them. He's not afraid of them. He's pushing in and going at them. He's not afraid of a gun. Yelling. Shoot me, N-word. Shoot me, N-word. Mr. Zeminski holding his gun down to his side, remembering this is a Black Lives Matter rally, and he's there to support their cause. Yeah, right. Mr. Huber, right there, holding him back, actually physically holding him back, but right in the middle of it. Look at the anger in his face. This here, I'll start it, but I'm going to point it out first. You saw a video earlier, this individual starting the Duramax on fire. Right here, jump kick, man. You see him shoot in the lighter fluid or flammable liquid. You see Jump Kick Man being right involved. This is the calm Tuesday evening that Mr. Binger is alluding to. Mr. Rosenbaum, this time wearing a blue mask, tipping over the porta potty. It was just a little porta potty. The trailer's important because it's the way he arms himself with the chain. Here's Rosenbaum pushing it. If he's just a regular demonstrator or misunderstood, a little bit upset, what does he need a chain for? What does he need a bag? Why didn't he leave it with Ms. Swart? Here, three things. The blue circle is bag, backed up by the fire. Look at that bag. Does that look like there's nothing in it? Look at this. What is that? That's not a water bottle, ladies and gentlemen. I can't tell you what it is, but it's not a water bottle. Look at this. 2 feet of chain on each side. He's got it. Taken, I'm sure, from right here. The toe chain. Jump Kick Man. Right there, the mask, the white jeans, the black. Look at the boots. Those boots would soon be impacting my client's face. Rundown Live. Here, once again, Rosenbaum, Zeminski at the trailer after it's been taken down the street, set up on its side, and started on fire. You can still see one of the chains hanging from the tongue of the trailer. Rundown Live. The state showed this video. I started my opening statement with it. I was going to show you where Mr. Rosenbaum is. I've already done it. Don't need to waste your time. How do I get to the end? Oh. Here's the picture that we showed at the beginning. Right there, the 125-26. Mr. Rosenbaum masked with his chain during the Rundown Live video. Mr. Rosenbaum with the chain. So I said earlier, look at how Kyle's dressed. Look at the pack on his left side, left hip. The crosses going across the front and the back of his chest. Nowhere in the magic picture is that depicted. 11:40, he's crossed over that line, asking people if they want medical, runs into Yellow Pants. He walks away from confrontation. And Yellow Pants said, "You pointed your gun at me," and he goes like this, low ready. The individuals who were there with him, slingshot, rocks in the hand, gun. Mr. McGinnis. Kyle, after having the brief thing with Yellow Pants, he goes away from them, goes over, looks for Mr. Balch. They might have been close to one another, but they did not find one another. He tries to go back. Wants to get back to car source 2. After that, he goes back and waits. He gets the phone call. He testified about the phone call, either from Nick or Dominic. And what does he do? He gets a fire extinguisher. He hasn't had a fire extinguisher all night, but he gets a fire extinguisher. The circumstantial evidence shows the call came through. He testified the call came through. You know, if it wasn't in his phone, the state would have brought it up. But now they're playing games once again. This is Drew Hernandez's video. It starts in color and goes, starts in black and white and goes to color. You have Jump Kick Man, the Zeminskis, and you'll hear Kelly Zeminski talking. And during the first part of the trial, we saw this trailer go by, and it cut off the view from this location. And I'll stop it a few times. And did you hear that? Talking about a pepper ball exploding in her ass. That's Kelly Zeminski's.
What up, what up, what up? I'm trying to figure out, how did it get to the Ahmaud Arbery trial? I done left, came back and everything. How did it get there? Wait a minute. So y'all got the 2-for-1 deal, huh? Yeah, y'all got a 2-for-1 deal. So they switched from Ahmaud Arbery and went to Kyle Rittenhouse. My. These people.
I painted my nails with Essie Expressi. I got Express to.
Shout out to everybody that hung in there. You know, I'm gonna see something. What in the world? Hold on, y'all. It's over. So let me ask this question. Well, no, I'm gonna come back. I'm gonna go back and look at some stuff because I wasn't able to look at everything today. So I'm gonna come back and look at some stuff. I'm seeing some stuff that's going on that I ain't liking. Shout out to everybody that's here. So let me ask you a question. Let me ask you this question. Are they moving for a mistrial, or the defense is trying to move for a distrial? What's going on with that? Are they trying to say that it should be a mistrial? This is crazy. It's crazy. But look, let me get up out of here. And we're going to talk about it when I come back. All right? Y'all be blessed.